As per the earlier order, they have filed their affidavit in opposition, my lord, by respondent number 6, but that was not with the record. Therefore, I pray for adjournment. They are here, but no objection to it.
Item 44 at the request of Learned Counsel. I understand the adjourn for 2 weeks.
Okay.
Item 46, on behalf of the petitioner, rejoinder has been filed. Lordship. May I kindly allow to bring it on record?
You have filed it today.
Yesterday, Lordship.
Okay, come on some other date. 46.
Yes, Lordship.
They submitted on behalf of the petitioner that a rejoinder affidavit has been filed. And yesterday, accordingly, the matter will be treated after a week. Please speak to an
Any date.
rejoinder affidavit filed to be connected to the case report.
Lordship, in respect to item number 11 of part 2, Lordship, I have some difficulty to read, Lordship. Lordship may take up the matter on Thursday, Lordship.
All right, item 11 part.
Yes.
Not to be called up today.
May it please, your Lordship. Lordship, I beg to mention a series of matters of tax for listing, Lordship.
Thursday.
May I please? Well, I beg to mention item number 53 of supplementary list, madam. On behalf of assessor, madam, he is out of discussion, madam. Further, madam, I have taken the concern of Mr. R. Mujumdar, madam. Advocate for the petition, madam.
Item number
53, madam.
53.
It will be taken up after 2 weeks, madam.
53 at the request made on behalf of Mr. R. Mukundar.
No, well, I am for madam. Assessor, madam, CGC, madam. For respondent.
On behalf of Mr. S.S. Roy, CTC matter stands adjourned. We listed after 2 weeks. We submitted the consent of the counsel to the petitioner and has also been obtained. Yes.
All right.
May I please, Lordship? Lordship, I beg to mention listing of the WPC for admission. Lordship, last it was listed on 10/1/2024.
List on 20 May.
20 May. May it please, your Lordship. Item number 43, my lord. Yesterday, I had filed 2 affidavit in opposition, my lord. Record may be kindly called for, my lord.
You served copies.
Yes, my lord.
43.
43, my lord.
All right. Call for the
Obliged.
affidavit. Yes.
May I please, your Lordship. Lordship, in this series, would like to withdraw only item number 49, your Lordship.
Only 49.
Yes, your Lordship. We have received the notice only in respect of item number 49.
Item 49 at the request of Learned Counsel for the petitioner, it was submitted that the petitioner does not wish to press the petition any further. Therefore, the same stands dismissed on withdrawal. In order, if any stand vacated. The WPC, that is the other items 50, 51, 52, we segregated and listed separately.
Your Lordship, liberty may be granted to file
File?
afresh. Liberty to file.
Okay, item 49, dismissed on withdrawal with liberty.
Black.
Mr. B. Chaudhary appears for the respondents.
Black.
Yes.
May it please, your Lordship, may I please the matter may be have taken the consent of my respected senior. Can the matter may be taken up at 2, your Lordship?
At 2.
Yes, sir.
At 2.
The whole series, my lord?
Yes, yes.
Whole series. 54. Pass over.
The Prosecutor Senior is just coming, he's on the way.
I don't think this matter belongs to this bench. You're challenging the dismissal. It's a formal proceeding, huh? It should be listed before appropriate bench. Does not belong to this matter. Matter pertains to challenge to the disciplinary proceeding initiated against the petition. Accordingly, matter be listed before the appropriate bench, taking out the roster.
Item number 45, right?
So that matter pertains to, it's a challenge to the disciplinary proceeding.
As well as both developed because the husband is already expired, father and husband. So while we are paying also the other benefit, the gratuity and
No, but first you'll have to
Yes.
challenge the disciplinary proceeding.
yes, yes.
So disciplinary proceedings does not fall under this bench.
But earlier official lordship had 2-3 times heard the matter.
Perhaps by by overlooking,
Yes,
but prima facie, it is a first challenge to the disciplinary proceeding, isn't it?
yes. That is
Unless that some order is passed,
yes.
consequential benefits and reliefs may not be available.
Well,
So in that context, proceedings are not before this bench.
as you
We,
know,
we directed the matters to be listed before appropriate bench.
not immediately because there are very maroon mallet
Be listed,
lady and
by Friday,
Friday mallet.
on Thursday, be listed day after tomorrow,
My, yes,
day after tomorrow.
pass, pass.
Yes, item, 47. It's not provided. Display.
Lordship, in this matter, Mr. D. Mojumdar is appearing. He is on legs in port number 17. I have just been informed by his junior.
Where is the counsel for petitioner? Yes, okay. Keep it aside for the time being.
Well, in this case, they have filed one affidavit yesterday, my lord. Lordship may kindly take up in some other day, my lord.
It is submitted that an affidavit,
My lord, two affidavit, my
two
lord,
affidavits have been filed by the respondent department yesterday.
yesterday.
The copies of which have been served on the counsel for the
Yes.
petitioner. The writ petitioner therefore craves fee for filing a reply affidavit. If so advised. Accordingly, matter stands adjourned for 3 weeks. 3 weeks?
2 weeks.
2 weeks.
Much obliged.
Obliged.
Yes, what happened?
Lordship, I have filed my affidavit, Lordship. The last occasion it was not there. So He's coming, Lordship. Petitioner advocate is coming. Lordship, may kindly take up my affidavit, Lordship. File on 6/5/24.
Yes,
So,
reply affidavit.
reply affidavit. The facts of the case is that Lordship challenging the transfer order that I have also annexed in my this affidavit, Lordship, annexes B and C, Lordship. That is of 2023, force order number 24, 2023 and 26 of 2023,
Yes,
by which some persons were transferred, Lordship, whose tenure are already completed. The petitioners are from both the transfer orders, Lordship. Here, they challenge this transfer order, and in the transfer order, their main ground was that, Lordship, that was done in the midway in the month of July. But as per the directive, Lordship, it should be in the month of before 31st of March of every year, so that their children's education will not hamper. Thereafter, Lordship, the railway, they file a writ petition, and during the pendency, notice was issued, and Lordship will find the relevant portion of the page 148. From paragraph 3, it will be clear, Lordship. Page 148, the order, paragraph 3, 4 and 5. 4 and 5 are the grounds on the basis of which they have challenged the transfer order.
one 48.
148.
Yes.
Oh.
Then what happened?
Lordship, my senior is on the way, he's coming.
What can I do? You argue? Yes,
Lordship, the Railway Board in the Ministry of Railway, Government of India, so issued directive number 58 pertaining to transfer of the members of the force, specifying that all transfer of the members of the force shall be governed by the provision laid down on Rule 90 to 93 of RPF rule, and the said policy was issued under Directive 58. Clause C of the said directive issued on 13/3/22 relates to periodical transfer, and clause 19 of said clause C provides the process of annual transfer, which reads as follows. The process of annual transfer, all annual periodical transfers shall be processed in the month of January every calendar year and completed on or before 15th of March or before end of the local academic session, whichever is earlier, so as the officer and staff so affected would get sufficient time to plan for setting of their families and admissions of their wards, as the case may be. Clause 29 of clause C of said directive number so and so reads as follows. The entire process of periodical transfer, including sparing and joining of the member of the force at the transfer place, shall invariably be completed on or before 31st March of every calendar year. Thus, for all the person having joined their new places of posting on or before 31st June, the deemed date of start of their tenure shall be 31st March only. In all other cases, the tenure shall be counted commencing from 31st March of the next calendar year. The petitioner submitted that though as per requirement of clause C19 noted above, annual periodical transfer is required to be processed in the month of January every calendar year and should be completed on or before 15 March or before the end of the local academic session, whichever is earlier, so that the officer and staff so affected would get sufficient time to plan for setting of their families and admission of their wards, as the case may be. It is stated by the petitioners that by the force order number 24 of 23 and force order number 26 of 23, both dated 21/7/23, issued by the Principal Chief Commissioner, NF Railway, transferring the petitioner from their respective places of posting in the midst of academic session of their children, are in violation of the provision of clause 19 and said directives dated 13/3/23. Petitioner stated that their children are studying ranging from class 1 to 12 in different schools in their respective places of posting. Hence the petition by the petitioner praying for setting aside and was the so and so impugn orders by the Principal Security Commissioner. It is placed before the court that the Inspector of Railway Protection Force, Guwahati, by communication dated 24/7/23, spared the petitioner number so and so, serial number and so and so. Thereafter, Lordship, now Lordship, paragraph 12. During the deliberation in the matter, so and so placed before the court a communication of the Railway Board, Ministry of Railway dated 31/7/23, issued by the Deputy Inspector General Railway Board, communicated to all the Principal Chief Security Commissioner RPF of all zonal railway of India pertaining to say directive number issued on 13/3/23, noted above, clarifying that the Railway Board in the Ministry of Railway Government of India have granted one-time exemption for completion of periodical transfer of Railway Protection Force personnel till 31st July 23 in place of 30th June 23 for the present financial year, and that the date of start of their tenure shall be deemed to be from 31st March 24 only for the purpose of tenure transfer, which has the approval of the Director General of RPF. In view of such one-time exemption issued by said communication dated so and so, on such the prayer of the petitioner made in this writ petition has become infructuous, as their tenure on such transfer issued under post number so and so shall now be deemed to be from 31st March 2024. Accordingly, this writ petition being infructuous stands dismissed. So, Lordship, thereafter, they had filed another writ petition, and in that case, Lordship, Annexure F, final order was passed on 17/11/2023 because some were spared and they have surrendered spare orders. This also, Lordship, same, and page 155, Lordship may kindly see. Here also page 155, as the petitioner are still in their place of posting and they have been allowed to rejoin their new post, that is subsequent posting on transfer up till 31/3/24, the present writ petition is closed as infructuous. So it was not on merit, Lordship, but because of the 31/3/24 is the date fixed by 21/7, so that order remained, Lordship. The only thing is that their transfer will be effective from 31/3/2024. Subsequently, Lordship, now this writ petition, they have challenged that on 8 March 2024, page 91 of the writ petition, this letter was issued, transfer of member of the force so and so in our judgment. With reference to the above, it is to inform that by force order number so and so dated 21/7/23, total 108 officer and staffs were transferred to divisions over NFR through TMM. Challenging the force order, few RPF personnel have filed WPC number so and so before the Honorable High Court, which was closed by the Honorable Court on 17/11/23 with passing the following judgment of order. As the petitioner are still in their place of posting and they have been allowed to rejoin their new posts, the subsequent posting on transfer up till 31/3/24, the present writ petition is closed as infructuous. Accordingly, in compliance of the Honorable Court's order dated so and so, it is requested to direct all the RPF personnel to report at their new place of posting on or immediate after 31/3/24 to carry out their tenure transfer issued by so and so and so and so. So thereafter, this 15/3/24 and 18/3/24, 23/24, these are written to different divisions in compliance of order dated 8/3/24. And these orders were of 15.
Their essential, their grievance was that some persons
Yes, Lordship, I'm coming to
were
that.
considered.
Yes,
They have not been given that.
Lordship. Thereafter, a new directive were enforced, Lordship, for those transfer which are for this present year. Those were for the last year only, in view of the exemption granted by the Railway Board. This new transfer, there is a clause that the persons will get 3 choices of posting, which was also there, but that was not their challenge in those writ petition, and some had also got that opportunity also. This new directive came into force from 20. This for the new transfers, Lordship. And according to them, some persons who were already in the earlier list also got similar benefit, but they were not given, Lordship. That my affidavit, I have stated that because of some clerical mistake, 2 persons, we have name also, they stated about 1 person, Ramesh Chandra Rai. I have given the list that 2 persons' name were wrongly included in the present year list. That is only a mistake. typographical or clerical mistake. And we have clarified that, and already we have spared. No benefit was given to them. Only in the list their names were. I have stated in my affidavit, Lordship. Lordship may kindly take up. Yes, Lordship. Page
What is
120.
the difficulty in giving them the option?
Because that at that time that directive was not there. What they have challenged, that was still remain. That was not set aside nor was. And this is for new transfer. Two persons' name. One is Ramesh Chandra Rai. We have stated in page 124 was erroneously included in the current DCS list. However, later on, realizing that the transfer order of Constable Ramesh Chandra Rai was already in force, force order number 2423, which was deemed to be effected up to 31/3/24. His three choices of posting were not considered, and his transfer.
What we are asking you
Yes, Lordship.
is that there is a office circular now
Yes.
saying that you give three choices of posting, three choices of posting. Now, maybe that this is come with effect from a particular date.
Lordship.
What is the difficulty of the officers of the authority?
In that case,
consider?
Lordship, by the earlier transfer, we have transferred 108 persons.
Hmm.
And few 16 are here, Lordship. One had already joined in his, out of his petitioner number 6 already joined in his place of posting, Lordship. Now all 108 will come, and which is not possible. If I will get the benefit to the petitioners, others will come for in the name of equity, Lordship. But actually, that is for the present posting. We have that option is here, Lordship. We have to give them because that will for DCS transfer. If we give them the earlier transfers, then the orders are already remain, Lordship. High Court has not set aside those orders. Neither their prayer was that at that time. They were very much happy with that 1 year. Their grounds already stated. That was not their ground. Now that will remain. We cannot given choices to again on 108. Many other will come. This is the
Out of
difficulty.
108 million, only 17 was before the court.
That
And the
other
other
will
has
be-
already joined.
No, they say that 17 are here, but
Hmm.
if the order is given to 17, then the benefit has to be extended to all.
The other has no complaint against the transfer order. They have joined in the last year.
If someone had any individual grievances, after joining, they may submit that, Lordship. Their provision was there.
But in your earlier writ petition, it was held to be infructuous.
In fact, because of the, my lord, because of the
You
railway
did
board order.
You did not raise the objection that your option of three choices was not offered to you.
I have challenged the repetition, challenging that I have not given the benefit of the
Clause 19 and 29.
clause 19 and 29. It is a violation of the guideline.
What is
Now-
that clause 19?
That I have that education.
Now, your lordship, kindly see annexure 4, page 38.
Page
38.
38.
38.
Yes.
This is the one-time exemption, Miller. Reference above, one-time exemption has been granted for completion of periodical transfer of RPF personnel till 31st July 2023 in place of 30th June 2023 for this financial year of 2022-23. The date of start of the tenure shall deemed to be from 31st March 2024, only for the purpose of tenure transfer. So, Miller, before completion of 31st March 2024, new guideline has come.
So this new guideline is for new posting.
No, Miller, because the one-time exemption has been given for tenure transfer. It is applicable to all. So before 31st March 2024, revised guideline has come.
It has to be because we have to complete
it
the
effect
transfer
should-
by 31/3.
It effects is to be given after 31st March 2024.
Now you show the guideline, revised guideline.
Revised for 73, starts from page 73. And it came into effect from
73.
It came into effect from 18/3, but in our case, I have already stated that on 8/3/2024, thus there is direction to spare all the persons that I have already shown your lordship. Page 9. page
So
91.
where does it say that it comes from which date? What is the date?
The last page, Lordship, page number 87. This is 18/3/2024.
Effect will be prospective.
This shall have immediate effect.
It-
18/3.
Yes,
Okay.
Lordship. It has to be before 31. Otherwise, this year also they will come that they have not completed this year's transfer also before 31/3/24. But their orders, Lordship, next page, their orders to spare these persons were of 8/1/2024. Although they had not challenged 8/3/2024, they had challenged the subsequent orders only. 8/3/24 was not challenged by in the writ petition. This is in view of the earlier transfer order. So before this directive came.
This order was passed in view of the order passed by the Honorable Court.
In fact, they were spared
But-
before.
But why do you say that this will not affect the transfer orders which are to take effect from 24th of March? Sorry, 31st of March. This has come into effect on 18/3.
Because those were of our previous year's transfer
So
orders.
from where do you say, if you read this directive, it says all transfers. All transfers. You read the opening line, all transfers of the members, so and so laid down. In furtherance of these intents,
Yes, Lordship, because all
the
transfer,
following guidelines are to be issued.
all transfer which was after 18/3. There were not of 18 after 18/3. This order 8/3/24, Lordship may kindly come to page 91. That all have of 8/3/24.
Does it show anywhere that this will take into effect all transfers which have been issued earlier? No.
No, Miller.
Those were their Lordship. Those were not set aside. Neither they have challenged
Now,
the.
if it does not include the earlier transfer orders,
Yes.
then how are you claiming the benefit?
Because my lord, your lordship kindly see again, my lord, the exemption order, one-time exemption order.
Page number?
Page number 38, my lord.
Yes.
Clearly said, my lord, the date of start of the tenure shall be deemed to be from 31st March 2024. So I am safe till 31st March 2024, my lord.
That is
And
with,
in view-
that is in respect of a transfer which was issued earlier.
Earlier, it was exempted.
No, it was not, it was extended.
Exempted.
Benefit was extended.
My lord,
Transfer
Millet-
order, your transfer order, what is the date of your transfer order? It is not 31st March.
21/7/2023.
So 21/7/23
20.
is the date of your transfer.
Yes, my lord. Thereafter, one-time exemption has been granted. And
Correct.
because of this, my lord, the writ petition has become infructuous.
Huh.
There is no need to challenge the transfer order. And my submission is this, my lord, because of this exemption order, the transfer order has also become infructuous.
No.
How? Because, my lord, one-time exemption has been given. And the effect will be start from 31st March 2024. And
Ah.
in the meantime, before completion of 31st March 2024, revised guideline has come. my lord. So I am entitled to get the benefit of the revised.
Doesn't appear to be. Your transfer order stands.
Now I am challenging, my lord, the transfer order.
No, you are challenging it,
Yes,
seeking an interpretation that by virtue of this
I mean, exemption order, I
Exemption.
mean, yes,
it has become infructuous.
yes.
That is not,
I have
that
challenged,
cannot be, how can you draw that inference?
my lord, I have challenged the transfer order not only for violation of the revised, also for the violation of the
your
directive number 58 also.
Your transfer order was issued by an authority giving you an exemption. Now, in order to make this transfer order infructuous, there has to be some order from the authority saying that all other transfer orders stand
cancel or something.
exhausted or a fresh order
Yes,
will be issued.
yes.
No such order has been passed.
No. That's why, my lord, I have challenged the present edition for violation of the earlier directive number also, as well as the revised.
What is the earlier directive?
Earlier directive, directive is at test 48.
40,
48.
48.
Sorry, 40, it starts from 46.
Where is the directive?
Here also, my lord, there is a provision for choice. My lord. Case 54. Close 7.
Clause?
17.
No, page number
54.
54. Yes.
All the officer staffs under zone of consideration for transfer will have to submit option of all units where they are eligible to be posted in descending order of choice. For example, if Shyam Kumar Constable is to be transferred from LJN division to some other division of NER, he has to give option in descending order of choice of all the units. There is the provision. That has
These were the earlier guidelines.
earlier again. That has also been violated.
At
That is
this
also under challenge.
PMA modular was there, Lordship, and Lordship next page, next clause, Lordship. So all the officer and staff shall be required to fill up their choices of posting within 1 month of freezing and posting of such data for their perusal. After the expiry of such period, no further modification will be permitted. The technical shall RPF shall make necessary configuration in the TMM application and mobile app in accordance with the provisions mentioned above. So that was there. It was not that that was not there. The TMM modular was there and computerized. If someone has got that, that got. Now that directive will override 18324. But their transfer orders were neither set aside nor quashed. So it remains.
No. If this was the circular prior to 83,
Yes.
are they entitled to a choice of posting?
At present, how good Lordship? At that time, they have challenged 2 clauses for their benefit. They are agreed to
I'm
their.
asking you a question, you give me an answer.
Yes. Lordship, it is.
The question which the court wants to know is that under this circular, earlier circular,
Lordship.
was there a provision for giving an option for choice of posting?
That is their clause. Next clause is very much clear, Lordship. Within 1 month, if they could have TMM modular is there, Lordship,
Okay.
not mechanically.
There is a provision, but they have to give it
Yes.
within 1 month,
Yes,
which they did not.
they did not.
There are only one more thing. Your Lordship, kindly see my additional affidavit page 106.
They are coming with different prayers, Lordship. What is their prayer in the repetition? Then subsequently their cases that somewhere given benefit. That was also I have cleared in my affidavit that no benefit were given. Although 2 names were wrongly included, but
Your Lordship,
we have not given the benefit.
Annexure 13.
Hmm.
The person who has been subsequently transferred, he was transferred earlier, but his case has been considered in view of the revised directive number. He was also transferred earlier.
No, but
No, Lordship. That is already submitted. I can I have already stated
If
that
his case can be considered
No.
subsequently, how?
that is already submitted and he is very much aware of that submission. Then also again he is repeating. I'm showing Lordship. There is a provision to submit if anyone has any individual difficulties. That person has submitted representation that his wife is also a employee of Sarva Shiksha in Guwahati. That is why his case was considered. And I have already submitted.
why
that.
don't you consider, why don't you allow him? to
That is,
submit?
I'm not saying they individual grievance they may have,
Huh.
but that they have to submit before, in fact, before this transfer order of 31 we have to adjust him. They had not. Then also, if someone had really very generous reason, Lordship, they can submit.
He was
individual.
transferred on 21/7/2023. He has also challenged the same will before the court, the same position. But his case was subsequently considered in view of the revised guideline.
Not revised guideline.
Revised guideline
Not revised
was
guideline.
not, he was earlier transferred to Katihar.
Where,
Now Rongia.
where is his consideration order? Is it available somewhere?
Yes, Lord.
110, and
Yes.
except 14,
He had annexed it.
serial number 6.
It is
Sorry,
received, no?
110.
It is received, no?
What is your grievance of not going for transfer?
Miller.
What is your ground for requesting for a revision of the transfer?
Because my lord, my choice was not considered. Option of
What are the, other than that, is there any other ground?
other than my lord, I have already submitted my lord.
Your Lordship, those person who had applied under this.
If
How
you
his
look into
case
page, if you look into page 110,
100.
there are 5 grounds.
Yes, ma'am. Subsequently,
Do you fall in any of these grounds?
no, Miller.
Then?
But his case has been considered subsequently.
Because he falls in any of these grounds,
He was earlier transferred,
but he falls in any of these grounds.
so that transfer order has been modified.
Because he
In-
falls in any of the grounds, one of these grounds, do
That-
you fall into one of these grounds?
And this is of 13/3/24. He had submitted
The-
before.
The grounds on
If
which
the
the transfer
opportunity-
is considered,
If the opportunity was given to us, Miller, we could have submit our choice of option.
I'm asking you, do you fall in any of these 5 grounds?
No,
If you fall,
no,
then we can direct them to consider it.
no, not in this ground.
Then,
Other ground is there, choice of option is there. His case has been considered, so let our case be also be considered.
no, his case is considered because,
There are so many grounds, Miller.
no,
He
but,
fall in one of the ground and his case has been considered.
no, in this, the criteria has been considered.
Yes,
These
Miller.
are the criteria.
These are not the
Wait,
criteria.
on-
There are some other criteria
All
also
were also
there
not
in
considered.
the
He was
revise.
not considered also. But his case was considered because he had a genuine
Why don't
reason.
you allow him to file a representation and consider the issue?
Individual representation, although it has to be before 31/3, because he had submitted this much prior, immediately. Then
Hello,
this
some
order
of us
was
have
of
submitted, but it was
13/3/24.
cancelled.
Now,
We
Lordship,
have
they are.
submitted. They have stated in their reply, Miller, they have cancelled. They said it was mistakenly taken, the choice of option, but his case has been considered.
That he is category totally different one. He submitted a representation much prior and after 13/3/2024. It is not
Where
only
is
he.
the letter referred in this order? 12/3/2024. Is there any letter like that?
Which one?
Page 110?
110, Lordship. This office order was issued. This person, those persons, in terms of so and so endorsement, so and so. 12/3/24 request transfer of the officer and staff of landing has been decided as per this. They had this all the person had submitted representation,
No,
but
no,
few
no,
were
no.
considered.
What we are asking you is in this office order, there
Yes.
is a criteria fixed. This
Yes.
criteria is as per the letter dated 12/3/2024. So this letter, is it available here, 12/3?
12th letter is not here. But now also,
Now,
Lordship,
their case has been considered in view of the Directive 58.
What is the new directive? 58.
revised 58.
It is early, their case has been considered, yes, Miller, Directive 58, you will kindly see serial number 2. Point
It
number
is
2.
not that they.
Being a
did not-
caregiver to a especially able child, as mentioned in Directive 58,
That
point
is
number
not
so and so, so
there.
and so.
When we said it is not
So,
there, that was
case has
there.
been
Lord.
considered, my lord, as per the directive.
And what are the other grounds in the
In
directive?
the directive, there are so many grounds, Miller.
Let us
This is
see,
one of the grounds. Choice of option of choice is there.
let us see, let us.
Yes, madam. Case 54.
Not 54. Option of choice.
Option of choice.
There's 53, in fact.
Hmm.
However, even eligible staff more than the modified vacancy of process.
You fall under which category?
9 and 11 was their clause. That was they had already availed.
Page 54,
54, which one?
17.
If they have any valid ground, they could have applied at that time.
Yeah,
But as a jointly,
Well, we applied,
Now-
that was cancelled. Recently, they have cancelled, when I pointed out before the court.
that should be before 31(3). This
How then,
Person
the
to-
case of Forgery was considered?
Now, see, clause number 16 is different. Clause number 16 is where there are more eligible staff than the notified vacancies.
Yes, sir.
So then the staff will be considered on the basis of the criteria later.
Yes, sir.
And in 17 is for giving a choice.
Sorry.
But that is with effect from 83.
My submission before I leave lordship is that.
Somebody may
when-
have been
when
considered, but
16 can be considered, 17 can also be considered.
no, if 16 can be considered, whether 16 was properly considered or not,
Yes,
is an
but
issue because
because your lordship kindly say 106, 110 may not, his case has been considered.
they could have availed that at that time. It's not that
We
they
have
were,
applied. They have come with a letter that.
they
it was
jointly they
rejected.
cannot come with, they, all them cannot have same grievances.
Same
Lord.
grievance because in
That-
our case,
that are
choices
two
was not
different-
considered.
different-
no,
concept.
no. They are saying that they want to avail the opportunity under clause 17, not under 16.
Yes, ma'am.
But that previously they have not raised that ground,
not
and
raised
those
it.
were still. Lordship may kindly come to page 76. The new,
But this choice of option was there in the earlier circular.
Yes.
yes,
sir.
So why you did not apply?
Well, I have applied it. One of the petition I have submitted the additional. They have said no, we have to follow the order passed by the High Court because High Court said it will give effect after 31st March.
in fact, Lordship, in the new
In
guideline
case of
also.
Sarveshwar, they have considered.
In fact, Lordship may kindly come to page 76. These new guidelines under which they are asking for
Not only
the benefit,
guidelines,
Lordship may, that is also not that absolute, Lordship. There is also, there must have been some sufficient reason. Lordship may kindly come to clause 5.
Let us come to the direction of the court.
Yes. This time also, Lordship, it's not absolute. The
Your
authority
Lordship, can I
has
say
the
Annexure 3,
reason to
relevant
decide.
question is at page 36, close 12. Paragraph
Page number
36,
6.
paragraph.
Yes.
During the deliberation of the matter, MS B. Sharma Learned Central Government Council placed before the court a communication of the Railway Board, Ministry of Railways, Government of India under number so dated 31st/7/2023, issued by the Deputy Inspector General, Establishment Railway Board, communicated to all the Principal Chief Secretary Commissioner, RPF, all Zonal Railways of India, pertaining to the said Directive number 58 issued on 13/3/2023. Noted above, clarifying that the Railway Board in the Ministry of Railways, Government of India have granted one-time exemption for completion of periodical transfer of Railway Protection Force personnel till 31st July 2023 in place of 30th June 2023 for the present financial year of 2022-23, and that the date of start of their tenure shall be deemed to be from 31st March 2024 only for the purpose of tenure transfer, which has the approval of the Director General of Railway Protection Force. In view of such one-time exemption issued by the said communication dated 31st/7/2023 by the Railway Board, the prayer of the petitioner made in this writ petition has become infructuous as their tenure on such transfer issued under force order number so and so shall now deemed to be from 31st March 2024.
What was the prayer made here?
In a
Because
previous,
Your
violation
prayer
of,
was that your children were studying.
yes, my lord.
It was never-
That time we have challenged only
that one.
one of the ground.
So
That was violated.
it was not your
So-
case, it was not your case that your options were not asked from you.
That time, my lord, that we have challenged only one or two ground, my lord.
Constructive res judicata.
Yes, Lordship.
But that writ petition has become infructuous in view of this, my lord. The one-time exemption. Now again, we have the right.
No, you have the right, but you have
To
to
challenge.
explain
Now
why you did not come. That option was available to you then.
Yes, my lord, because
That
since-
option,
since, my
that
lord,
option of applying for choices was available to you
yes, my lord.
at the time when you approached this court.
In our writ petition, we have said it is in violation of the guideline. So it includes all
But
the
you
ground.
did not, you did not press forward.
Well, specifically, we have mentioned that is in violation of the guideline, directive number 58. It includes all.
No, that is okay, but then you accepted this order.
Yes.
When the court said it
It's a
is
con-
Yes,
become
well, since it is
infructuous.
in view of the exemption order, my lord, it become infructuous. So effect will be start from 31st/3/2024. Till then, we are protected.
That's right.
Our
You're protected from what?
protected from
Transfer.
joining to other places. my lord.
On basis of what?
On the basis of this, my lord, the railway board order, 1 year exemption, my lord,
In respect of what?
in respect of transfer, my lord.
When was it issued?
21/7/2023. That's why,
It
my
is
lord,
not
I'm
a case that because of this exemption, your transfer order itself has become in.
Yes.
infructuous.
It remained. You had the option of giving
Now-
choices. You did not give choices.
But-
Assuming you made a statement or submission before the court that these are violative of directive number 58, on the court saying that it has become infructuous, you accepted this order.
Yes, my lord.
So if it is accepted, the matter is closed.
It
So
become-
how can we address on the similar issues again?
My lord,
See, either you say that this ground was never urged because that situation never arose, number one, in
Yes.
which case we can certainly take up.
yes,
If it is your case that no, you had urged this ground, it was not taken up, but you have accepted this order. You have to explain why you have accepted this order, because this will be barred by res judicata. Be barred. How can we now reopen an issue?
my lord,
Not exercising repeat.
my lord,
Somebody's case being considered under the
my lord, what would be what is the meaning of this one-time exemption, my lord?
Okay.
one-time exemption is, where is that page number 38? One-time
38.
exemption is granted till 31st.
Yes, Lordship. It's
Sir,
not only in
If in the
Assam, Lordship.
meantime, some policy has
First
been
case
changed,
was
my
in
lord.
Orissa, all those persons are already transferred. But
If in the meantime,
this
it is applicable
petition
to
also-
all the stuff,
You see the start, the date of start of their tenure
31st March.
is 31st March.
Yeah.
So tenure in respect of what? In respect of the transfer order.
So if in the meantime, any new policy comes, my lord, with regard to the
How will it-
transfer order,
No, unless the policy says that all pending transfer orders will also be effective.
it is written, my lord, in the
page 91 is clear, Lordship. Page 91 is very much
Your
clear.
Lordship, and it's page 46, my lord. My lord, sorry, my lord, page 73. The revised directive.
Yes.
All transfers of the members of the force shall be governed by the provision laid down in rules 90 to 93 of the Railway Protection Force Rules 1987 amended. So all transfers.
Was all transfer of 2024
Transfer.
onward.
And now another submission, Miller. If it is their case, Miller, then why the case of the Sarveshwar Das has been
We
considered?
don't know why it has been considered, but assuming it was, then
He has also applied. We have also applied.
Sarveshwar was considered under clause 16.
16.
You do not fall under clause 16,
I fall under 17.
17. But 17
Sarveshwar
clause,
case and
17 clause was already there in the earlier directive,
yes, Miller.
which you did not urge at that point when
No,
you.
his case has been considered in view of the earlier directive.
Hmm?
Earlier directive. Miller.
If they falls under clause 16, they can apply at that time.
No, where is the bar
No, no.
from applying
What
17?
what earlier directive?
Case 110.
110.
10. Point number 2, Miller. Being a caregiver to a specially able child, as mentioned in Directive 58, point number not revised.
Sorry. 110.
110, Miller. Point number 2. The ground. Being a caregiver to a specially able child, as mentioned in Directive 58. So, my lord, he was also transferred along with us. He was also before the court, Miller. His case has also become infructuous.
See, Directive 16 is on specific criteria. There are specific head.
Yes. If we do not fall any category, Miller, why they have cancelled out?
Directive 17 is only on the question of giving a choice of
Choice.
posting.
Choice.
Choice of posting and this criteria obviously stand on different footing.
Miller, please.
These are more
Acceptability is the
specific
same.
criteria. These are more specific. That it's not about the choice of posting. You don't want to be transferred because you fall in any or all of these categories.
Yes.
That is also available in new guideline also.
So if you fall into this clause 16, we can issue a direction that your cases should also be considered. But clause 17 is an omnibus choice of posting.
Miller, all these points,
Now,
Miller.
see, your choice of posting will now have to be considered on the point with the context of availability of vacancies also.
Yes,
Merely because you give a choice.
they may not consider. There is no issue. They may not consider because all these points falls under periodical transfer, close similar. So how the transfer order will pass, Miller? It falls under periodical transfer. So one of the ground is close 17, Miller. That has been violated. Let them consider, Miller.
One of the petitioner already joined lordship. Petitioner number 6 had joined. The benefit that they are now asking for, lordship may kindly come to page 76. In new guideline also, lordship, it is not that someone had applied and he will be given effect to. There is clause 76D, 5 and 7. Lordship may kindly say, cases of transfer of RPF staff who have completed 10 years at a stretch of 15 years in broken spell in a station shall be considered during periodical transfer, that is such staff shall be transferred out of the cities, town where they have spent 10 years.
Whatever ground you may have is a different issue. We are now trying to decide whether a direction should be issued for considering their cases,
Lordship,
for giving the option
lordship.
under clause 17.
But that is not in effect now, lordship. that will remain for them only because it was not set aside. But now they cannot come for benefit under the new guideline. The old guideline is over by 18.3.24 or 17.3.24. And this all transfer means whatever falls after that. Their order was not set aside, and I have already stated at that time they don't have any other grievances. That's why it is a consented order. They want that that should be on 31st March. That is done, Lordship. For this year, we have to before 31.
Where is that clause 17 again?
Page 54.
Page
54. Okay.
54.
17 along with.
This is the earlier guidelines,
Earlier guide.
but earlier guidelines are no longer there now. Earlier guidelines have been replaced by the new guidelines.
New guideline, but Sarveshwar Das case has been considered.
That is a totally there. He is now not
Under
come
the
with
new
clear hands.
guideline, is there a provision like that?
Yes, there is a.
Where is that?
That page 73, Lord. Page 76, Lordship. I have shown
7.
clause 7.
Clause 7.
That is, yes. Enroll member of the force who have been transferred from a station upon completing either 10 years in a continuous spell or 15 years in broken spell at that station will be eligible for posting back to the station solely on criteria of their last posting or on extreme compassionate ground, which is to be scrutinized based on merit and approved by the transferring authority on case-to-case basis.
Very well.
Ah.
We'll issue a direction to consider whatever orders you pass.
Lordship, individual, but before that they have to join, Lordship.
Why will that?
They have to
No,
join.
You consider it within a time bound period, and thereafter they will join.
Because, Lordship, in that case, system has to run,
Where
Lordship.
are you transferred?
Katihar.
In fact, spare orders were passed before issuance of the interim
Well,
order.
transfer
That
order has
was
been stayed.
has to be effective of 31/3/24 and interim order was of 3/4/24.
You consider it within how much time do you want? 15 days, 20 days?
Maximum, they have to submit their representation within a week, and by another 10 days, we will consider, Lordship.
Third learned counsel. These writ petitioners have. These writ petitioners are employed as what? Railway protection
Force.
It's
Constable.
constables,
constables under the RPF.
RPF.
So they have approached this court challenging the transfer orders issued to the writ petition. Transferring them to various posting. So earlier, the writ petitioners had approached this court by filing WPC 4405 of 2023, challenging the transfer orders. When were your transfer orders issued?
21/7/2020.
On 21st of 7, 21/7 to 2023. So during the pendency of the writ petition, an exemption order was issued by the competent authority in the competent authority of the railways that their date of start of the tenure shall be deemed from 31st of March 2024 for the purposes of the tenure transfer. So this communication was issued on 31/7/2023. So in view of this communication, the writ petition was closed on the ground that it had become infructuous. So then subsequently, why did you come? Second writ petition?
Yes, Lordship, that spare orders were there, they were not allowed to join. That is why they submit.
Even after the interim order, they started sparing us. That's why, my lord, we have again approached the court.
No, sparing is, what is the meaning of sparing you?
And then releasing me.
Really?
All the repetition disposed together, no?
What were, no, they were by
No.
separate code.
That is the notice of first order. Lordship had seen the first order, but disposal date is same. We have annexed disposal, he had annexed disposal date of another repetition.
17/11/2023.
Yes, 1711 is the same repetition.
Not same
Same, not
repetition,
same.
but that was also there. All the repetitions were disposed together. 3 repetitions were there.
They were filed together.
No, Miller. First, we
Sir,
have filed
it was
the
taken
earlier
together.
petition. We have obtained an interim order. They violated that, Miller. That's why. we
No,
again-
but you mean to say that prior to closure of the first writ petition, you filed the second writ?
Yes, yes.
Yes,
Eh, During the pendency of the earlier writ petition, interim orders were granted in respect of the transfer orders issued, which however, according to the writ petitioner, was not given effect to by the railway authorities, and release orders were issued. Stop. This compelled the petitioners to approach this court by filing another writ petition, which is 4744 of 2023. The subsequent writ petition also came to be closed as infructuous in view of the force order number 24 of 23. Sorry, in view of the communication dated 31/7/2023, whereby the tenure transfer was given effect from 31/3/2024. Stop. The present writ petitioner, the present writ petition has been filed seeking orders from this court that with effect from 18/3/2024, a set of new directives, being directive number 58, came to be issued. So, the petitioners have urged before this court that the benefits granted under directive number 58, including the offer of 3 choices of posting and consideration of personal difficulty in respect of the RPF personnel, was considered in respect of other similarly situated RPF personnel.
Only one. They are saying only about Sorveshwar.
Accordingly, the writ petitioners are before this court praying for issuance of a direction for consideration of their cases, or reconsideration of their transfer.
Lordship, one thing may kindly be,
37, issued by 337/2020.
Lordship, their prayer was not that in the repetition. Subsequently, they came up with the prayer was only to similarly situated person. That was not their prayer in the repetition.
violation of the guidelines.
They have challenged only violation of the guidelines.
That is,
The petitioners have prayed for setting aside of the transfer orders on the ground that they are violative of the provisions of the revised directive number 58. So,
both the directive.
revised directive, and what was the earlier directive?
That was also 58 and the subsequent revised directive.
Directive number 58 as well as revised directive number 58. Notice in the matter was issued on so and so date, and interim order was issued staying the transfer orders. Notice was issued on 3/4. You say by order dated 3/4/2024, this court granted an interim order staying for. The interim order passed earlier was extended from time to time. The respondent railway authority filed their counter affidavit challenging opposing the claim of the writ. Learned counsel for the petitioner submits that the petitioners were required to be called for the petitioners were required to offer three choices of posting as per the directive number 58 as well as the revised directive number 58. So this was obligatory on the part of the railway authorities to call for the places of choices of posting. So the same, however, was not done. That apart, similarly situated RPF personnel who were also covered under the earlier transfer order issued on 23/7/2023 was considered on the basis of representations furnished by them, and their transfer orders were revised. It is submitted that the railway authorities are duty bound to consider the prayer of the writ petitioner and allowing them an opportunity for offering three choice posting and thereafter pass necessary orders. Stop para. The submissions of the learned counsel for the petitioner are opposed by the counsel for the respondent. The learned CGC strongly opposes the submission that indicates that the transfer orders were issued on 23/7/2023 and the challenge made by the writ petitioner by virtue of two writ petitions being WPC number so and so and so and so came to be closed as infructuous. This court did not interfere with the transfer orders issued, and therefore the transfer order remained. And consequently, pursuant to the expiry of the extension period, the transfer orders are required to be given effect with effect from 1st of April 2024, and the petitioners are required to join in the new places of posting. So, it is submitted that the railway personnel whose cases have been reconsidered had applied under the directive number 58 on the criteria prescribed under clause D16 and on such grounds being heard before the railway authority, the case of the concerned RPF personnel were considered. So, it is submitted that insofar as the writ petitioners are concerned, their cases do not fall under clause capital D in bracket 16. However, if the writ petitioners feel that their cases are required to be considered under clause D16, they may file suitable applications before the competent authority, and the authority may consider the same. However, since their transfer orders were never interfered with by the coordinate benches earlier, and the extension period having been expired, they are now duty bound to go and join the places of posting as per the transfer order dated 23/7/2023. Learned counsels for the parties have been heard, meetings on report have been carefully perused. It is seen that the directive number 58 as well as the revised directive number 58 contains a clause that the choice of offering choice of postings to the concerned railway office, railway personnel in respect of tenure posting. Clause 17, clause D17.
It's C17.
Hmm?
It's C17. It's
C17, yeah. C17, capital C17 of Directive number 58 reads as under. You expect clause C17.
17 is connected with
Sorry, 16 and 17 reads as under.
18 also, Lordship, because
Page number 53, 54.
8,
As well as 18.
17 and 18, in fact.
The revised Directive number 58 also contains similar provisions, and the same reads as under. Which will be under clause
D7.
17.
7.
7. Page number 76. A careful perusal of the clauses reveal that both under Directive number 58 as well as revised Directive number 58, there is a provision for offering the choice of posting, which are to be considered by the competent authority on the criteria prescribed in the same clauses. Insofar as the clause number 16 is prescribed under clause number C16 as provided under the Directive number 58. It is seen that there are specific grounds on which any application forwarded by the RPF personnel can be considered. It is not in dispute that the petitioner does not fall under clause 16, clause C16.
Some of the petitioner may fall, I'm not aware, may fall. If they fall, they can apply.
Strike out the earlier. The grievance of the petitioners essentially is that while similarly situated persons' grievances are considered, the petitioners' grievances have petitioners have not been given an opportunity to avail the procedure prescribed under Directive number 58, read with revised Directive number 58. Stop. One specific instance of a railway personnel, namely railway personnel service soldiers.
Subsequently, they came with another, after that, they have filed another additional affidavit where they mention about Ramesh Chandra Rai. So on that basis, only Lordship directed me to file additional reply affidavit. And we,
Sorbeswar Das and Ramesh Rai.
Ramesh Chandra, Roy. But I have,
Pointed out by the counsel of the petition that their cases were considered.
no, Sorbeswar Das is considered, but Ramesh Chandra is wrongly, not because wrongly, for election duty, he was
were
not.
considered in spite of the transfer order, in spite of they also being covered by transfer orders similar to the writ petitioners issued on 23/7/2023. 21.
Ramesh was not considered. On 9/4, he was spared his earlier transfer. Ramesh was not considered. Only because of election duty, he was delayed.
This contention of the writ petitioner however, is disputed by the learned CTC, who submits that the Sri Ramesh Chandra Roy
Yes.
case was not considered and he was subsequently released in terms of the earlier transfer order dated
He
21/7/23,
joined on 12/4/24 at Romia Division.
and he joined in his place of posting on 12/4/24
24 at Romia Division.
at Rongya Division. So, however, she fairly submits that case of Professor Das has been considered as he has applied under clause C16 of the Directive number 58. Stop. The perusal of the Directive number 58 and revised Directive number 58 reveals that there are provisions for the railway authorities to consider the hardships and difficulties faced by RPFs in respect of tenure transfer. These directives clearly lay down the procedure prescribed for issuance of transfer in respect of the Railway Protection Force personnel. So, these directives are fairly exhaustive and the competent railway authorities are vested with sufficient powers to reconsider any such application or representation that may be preferred by the concerned railway protection force personnel, expressing the hardship of the difficulty in respect of the tenure transfers issue. So, while clause C16 under the directive of directive number 58 provides for specific grounds on which the priority should be given for for absorption in the notified vacancies by the railway authority. Clause C17 of Directive number 58 Railway, clause D 7 of revised directive number 58 provides for submission of options by the concerned railway RPF personnel towards places of their posting. So these options, upon being submitted, will have to be considered by the competent authority, and thereafter appropriate orders are required to be passed. So, having noticed such provision being available, these directives, this court of the view that at this stage, the restriction can be the direction of the commissioner to file individual.
Yes, case to case basis it will be considered. That is specific
For which authority?
for, I think,
For board.
yes.
Huh?
Number 4.
For the principal chief security of or his property right, namely respondent number 4, expressing their hardship in reference to the provisions of directive number 58, read with revised directive. Upon such representation being filed, the competent authority will individually consider to be represented and pass necessary orders. Since the petitioner in the transfer order have been stayed by this court is of the considered view that the benefit of interim order should be extended for a period of 3 more weeks. So the petitioners will file their representation within 7 days.
Yes.
From the date of receipt of a certified copy of the order, and within further 2 weeks therefrom, the railway authority will consider and dispose of this representation. Any such order that is passed, therefore, be furnished to the above location stands. Okay, 3 weeks, saying that order passed again till the representation stands.
One more submission. Well, the petitioner are constable, Malad. They are not paying their salary. Malad.
Any salaries or financial benefits?
At present, they are, in fact, they are not nowhere they are. The interim order will pass after their paying. So they are not here, not there.
But you can't stop their salary. We are passing interim order. We have not dismissed them. It is further submitted that the salaries of the RPF person that have not been paid. So the respondents will forthwith release their salaries, regular salaries. And
Difficulty is that now from where they will, from which place they will,
display because there is
Earlier-
an interim order.
lordship.
There's an interim order. What is the meaning of issue? Yes, Mr. Biswal.
My lord, other side is not represented, Mr. SP Chaudhary. He is absent today also. SP Chaudhary.
Yes.
My lord, in this case,
He is in charge of the matter.
Chaudhary appeared, but the institute requested me to observe the case. I have no brief, my lord.
Observe.
And participation. Let it be, my lord, connected, WBC is pending regarding punishment. So, my lord, they are pleased that that is still pending in the High Court. So may I pray that a little adjournment, short adjournment, that is matter is tomorrow.
But
It is submitted that
in this,
counsel for the LPRIMA SP Chaudhary. He is really, really good.
Don't want to take it, my lord, because he is already appeared, conducted this case, my lord. So I don't want to.
We are not
take-
asking you. Mr. HC, which was the case of the petition. Next week.
Your Lordship, if I may pray, the name of Mr. D. Mozumdar, additional AG may be shown in the cause list because he was not aware of this particular matter today.
You mentioned that he's on legs.
He is on legs actually.
Then-
He is on legs. That was he was on legs on court number 17. Item number 1. May I pray a short date, Your Lordship, showing the name of Mr. D. Mozumdar, additional AG in the cause list.
Yes, Mr.
That's not it.
But he was appearing in the matter.
He is appearing.
Then why should the name be displayed here? Is the advocate additional AG?
He argued the matter at length. In fact, he finished his argument. Therefore,
Perhaps he missed the matter, Your Lordship.
This is about the regular scale,
pay parity.
pay parity. Who is to decide on this pay parity?
The government, they have to they are saying that since we were appointed on part-time basis under the earlier rules, therefore we are not eligible. Our case, on the other hand, that we are
You are
doing
still working or is it?
see, no, some of them have already they have completed their tenure, 2 of them.
Submitted? That. that additional rate. Pray for adjournment.
Can you do 28th month? Date me fix.
We fixed it on 28.
Right.
The depth of work. Represents the report. Yes.
Lordship, may I present? Lordship is earlier on partly matter, Lordship. This is regarding non-payment of Lordship pensionary benefit, Lordship. Actually, his service book is lost, Lordship, the petitioner service book. A prayer is for Lordship reconstruction of the service book as well as the subsequent dispersal of the pension, Lordship. Initially,
Who's for the respondent? PWD?
Lordship, water resource.
Water resources. Who's for water resource?
RM and data. RM.
Yes.
Lordship, this initial appointment was Lordship on 10/5/1966, Lordship, as lower division assistant in the office of the superintendent engineer, North Town Road Circle, Lordship.
Your service book is not
Lordship.
constructed.
Lordship.
Where is the admission of the department that service book is not there?
Lordship. Lordship, may
Page 14.
Lordship, yes, page 13, 14, Lordship. This is one of the document, Lordship, an extra D, Lordship, page 13. Lordship, here is founded married. Other than Lordship, is acquaintance rule. No other document is found, Lordship. And subsequent to page 14, Lordship, this is my application, Lordship. The 40 superintendent engineer, what in investigation circle. And I have also submitted, Lordship, RTI application. Lordship, I have submitted it to the Secretarial Admissions Department because for 1 year I have served in the Secretarial Admissions Department in Shillong, Lordship.
But you were asked to appear before the authorities. You did not appear. Why?
Lordship, only subsequently I have, Lordship, submitted my only document, Lordship, whatever available with me, Lordship. This is annexure I, Lordship, is number 18, Lordship. These are the documents, Lordship. And annexure I, Lordship.
You submitted.
Lordship, I have submitted the documents, Lordship. Whatever available with me, Lordship.
Where is the standing counsel? Water resources. Mr. Bora. Please inform.
in paragraph number 6 of their affidavit in opposition lawsuit.
So I've informed the
Resign from water resources and then joined as a block development officer.
Lordship,
From where again you resign.
so far, in this,
This is what they say in the affidavit.
yes, Lordship, in the pleaded case in the writ petition, Lordship, he has voluntarily resigned, Lordship. Subsequently, after the termination of the
Voluntarily resign where?
from BDO, Lordship. Subsequently, from termination of the service from as a BDO, Lordship, he voluntarily retired from the service of the Water Resource Department as part of pleaded case. Lordship. Now, they have submitted a document, Lordship, to address to the minister that my document, Lordship, he has resigned from service, Lordship, because he was forced to resign from service, Lordship.
May I please your lordship? Lordship, he's in lapse with code 7, so kindly that matter be adjourned for the time being.
So this is a part two hearing matter. Can I adjourn it? You ask him to come.
Yes, lordship.
And then, Lordship, my resignation, Lordship, for the consent, it appears that because they are concerned with consent of the department, Lordship, he has resigned, Lordship. If this document executed it. Lordship Secretary Administration Department also admitted that due to setting of the records from setting of the capital from Shillong to Dispur, some service book has been lost. Lordship. It is the admitted question of the Secretary Administration Department. Lordship. It's an extra K. Lordship.
So
Yes,
from where will your service book now be reconstituted?
Lordship,
Reconstruct.
probably, Lordship, with the available the document I have submitted and the acquaintance rule, Lordship, it is that they have admitted that acquaintance rule is there. Is
What rule? What rule?
acquaintance rule,
Where is that?
Lordship may kindly annex D, Lordship.
D.
D, annex D, page number 13, Lordship. May Lordship, this is from the Superintendent Engineer Guwahati Investigation Cycle, the Deputy Engineer, Water Resource Department. Lordship. With reference to the letter number cited above, I have the honor to inform you that as per record available in the acquaintance rule, Sri Petition Bora ex LDA was working in the Disproportionate investigation cycle for the period from.
What is acquaintance rule?
Lordship, this is regarding Lordship, the financial Lordship, salary is that recorded in the record book, Lordship. How he has been growing salary, what amount, Lordship, as per the financial rule, Lordship. Working in the Lordship, period from November 1970 to February 1982 and had grown his pay there accordingly.
We have to close this repetition. It is a 2012 matter. His book, service book is to be reconstructed. So there is some material available in the office of the superintending engineer.
Lordship.
You reconstruct the service on the basis of that material and ask for whatever it is required. And on that basis, if he is entitled to pension, his paper should be forwarded.
Lordship, that's whatever we have asked the petitioner also to submit his service.
He will submit it. He will submit it within a time of.
He does not have that. Because once he has been given the opportunity of submitting the relevant.
No, he says he submitted.
Lordship.
In the petition.
Also, it is annexure
Page number 18.
Page number 18.
He says he has submitted all these. And this is acknowledged by the Tezpur investigation circle.
But in our affidavit, Lordship, in our affidavit, Lordship, if Lordship stated in paragraph 5, Lordship, in our affidavit, Lordship, page 4, Lordship, that is the affidavit filed by Dilip Kumar Sharma, that is Assistant Chief Engineer, Lordship, paragraph 5, Lordship. May I read, Lordship? It is specifically stated that there is no official record in respect of the incumbency of the petitioner in any office under the present department or prior to his joining in the present department could be found out. The only record available in the concerned office of the department is that the petitioner was drawing his monthly salary as LDA in the concerned office with effect from November 1970 till February 1982, and except that nothing is available regarding service of the petitioner in the present department. It is
but you did not, you have not disputed this communication.
Lordship.
Page number 18.
Lordship.
Is a communication from your department. You have not disputed it.
Then in paragraph page 5, Lordship, page 5, Lordship, that is 1, 2, 3, 6 number paragraph. Therefore,
Yes.
6 number paragraph. Therefore, the petitioner was asked to attend the office of the concerned authority with all required documents, but the petitioner failed to furnish the same in spite of due persuasion on the part of the government in the Water Resource Department and its subordinate authorities. In the name of the documents, the petitioner has only submitted one certificate under the heading to whom it may concern, having mentioned his incumbency, and this certificate was issued under the signature of Jamir Uddin Ahmed, the then Superintending Engineer, Tezpur Investigation Circle, who was the secretary to the Water Resource Department, now retired, and the petitioner failed to produce appointment letter, joining report, transfer order, pay down such statement, and
No,
etc.
that,
And hence,
that is okay, but we are saying that there is no specific denial of page number 18. This is issued by your Tezpur Investigation Circle,
page number 8 of the
XLD. Oh, this is sorry, this is by the petitioner himself.
Petitioners.
This is by the petitioner himself.
This is by the petitioner.
No. The left hand side, there is some endorsement. On the left hand side, there is some endorsement. Lord.
In this paragraph, Lordship, we have said everything, Lordship.
What documents do you have now?
Lordship, I have talked to them. I have tried, but they could not find
Unless
out.
the documents are available, how your service book will be reconstructed?
Lordship, in paragraph 6 of our affidavit, Lordship, regarding the certificate, it has been specifically stated that this is the fake certificate, fake signature.
Which one?
Lordship, in paragraph 6 of our affidavit, sorry, page 6 of our affidavit, Lordship, it is specifically stated.
Where?
Page 6, Lordship, second paragraph, Lordship, it is specifically stated that the only certificate as mentioned above under the heading to whom it may concern, as submitted by the petitioner, was also duly verified and examined, and on such verification and examination, it was found that Jamir Uddin Ahmed did not issue the certificate, and his signature was tampered and fabricated, and as such, the only document was also not an authentic one, and hence cannot be relied on.
What about the
Whatever, Lordship,
what about the acquaintance rule? What is the acquaintance rule? Page number 13. What is the acquaintance rule? There are some information available there.
Yes, Lord, that we have admitted that he was, means, this is the certificate.
So if you have admitted, then whatever documents are available, you have to furnish it. Prepare the pension papers and send it. He has admittedly completed 12 years.
Because we have already admitted in our affidavit, Lordship, we don't have any documents regarding that in relation to the petitioner, only his.
No, you look into page number 13.
Lordship. Yes,
It is a document by the superintending engineer.
Lordship.
Admitting that he has worked from November 70 to February 1982. So if this information is available in the document, in the department, on that basis, you prepare whatever service book you can prepare and send it across. His pension can't be denied.
Lordship, that pension cannot be. Let this matter, may I pray that let this matter be remanded back to the department and let the petitioner approach, and the department will act accordingly, Lordship. Within a time frame, Lordship.
Yes. heard counsel for the next petitioner before this court is agreed by the non-release of its pension by the respondent department. So, petitioner initially came to be appointed as an LDA 10/5/1966 under the PWD. On his transfer, he joined the Assam Secretariat 1968 Shillong, and in the year 1970 he was placed under the Flood Control Department, now Water Resources Department, and there he served till February 1982. So, the office of the respondents were subsequently transferred from Shillong to Guwahati, and the services of the petitioners were regularized on 1972 with due increments. In the year 1984, the petitioner was appointed as a block development officer under Regulation 3F on temporary basis, and he continued his services till December 1989. So, as he failed to clear the APSC examination, his service as a BDO was terminated. Although the petitioner represented before the authorities for offering him a second chance to appear in the APSC examination, but the same yielded no result. Thereafter, the petitioner tendered voluntary retirement in the year 1991. Thereafter, the petitioner has been approaching the respondent Water Resources Department, praying for release, praying for furnishing his pensionary papers for release of pension. So, the petitioner submitted his pension application along with all relevant documents. However, in spite of that, the pension was not submitted. So, his several representations before the authorities, including the departmental minister, yielded no result. His prayer for reconstruction of his service book for the purposes of processing his pension also yielded no result. So, upon an RTI application filed by the writ petitioner, he was informed that several official reports upon its shifting, the shifting of the state capital from Shillong to Dispur in 1974 got misplaced, and the same could not be traced out by the department. So, being thus situated, he has approached his court by the instant writ petition. Counsel for the petition submits that as per communication dated 6/12/2004, issued by the superintending engineer, the deputy chief engineer of the resources department, in bracket NHD, page 13. As per the records available in the acquaintance group, the petitioner worked as an LDA in the Tejpur investigation circle for the period November 1970 to February 1982, and had drawn his pay there accordingly. However, no further records, including service book and personal file, were available in the office. Learned counsel, appearing for the petitioner, submits that pursuant to that the petitioner had approached the department and had furnished the list several documents by his representation dated 1/2/2013, which was also duly received in the office. In spite of such attempts made by the petitioner, no response was received from the department, and its service book has not been reconstructed nor detected. There are still cutting of water resources department, the applicability, he submits that there are no official records in the office of the department insofar as the petition is concerned. The only available record is that the petitioner was drawing monthly salary as LDA in the concerned office with effect from November 1970 to February 1982. Stop. That apart, there is a categorical averment in the affidavit that a certificate which was stated to have been issued by a former superintending engineer upon due verification has been found to be not authentic. So, the learner, the petitioner has filed a rejoinder affidavit reiterating his submissions made in the writ petition. So, learner counsel has been heard. The peculiar case of the petitioner is that he had rendered service at a time when the capital of the state was in Shiloh, and unfortunately during the transit of records from 1974, certain official records are still with the state, and consequently no record with respect to the dedication are found available. The only record available as admitted by the department, only record available with respect to the dedication as admitted by the department are the record with regard to Royal of Seven as LPA for the period November 1970. Documents stated to have submitted by the petitioner are also not specified. They even accept that the certificate stated to have been issued by the superintending engineer was upon verification of such circumstance that can be closed directly responded for part to reconstruct the service of the records and materials the petitioner will also approve the card furnishing is relevant. The competent authority. The department will thereafter forward the pension proposal upon due verification of his service particular and tenure. We forward the pension paper to the competent authority and competent authority thereafter. Okay. What is the competent authority? AG?
AG.
Accountant General or Accountant Authority in the Accountant General. Thereafter, release the pension. The department will forthwith proceed to reconstruct service of and also process the pension petitioner will offer relevant necessary documents related with him for facilitating the pension proposal being prepared and forwarded to competent authority. With the above observation, the petition stands allowed and closed. The department will endeavor to prepare the pension papers and submit the same within a period of 60 days.
90 days.
90 days from the date of receipt of a certified copy of this. The petition accordingly stands closed. The court expresses gratitude to the legal aid counsel, Mr. Boyd, who has rendered assistance in disposal of this. Standing counsel, Mr. Aranda.
Petitioner should furnish the document, relevant document which he have.
He will.
Directive may be given.
The petitioner will furnish within 2 weeks from the date of receipt of certificate.
Lordship, the bank is to complete the instruction, Lordship. The respondent are yet to complete the instruction, Lordship.
Respondents are yet to complete.
Yes, Lordship, the instruction.
Where is the respondent?
The UCO bank.
If he is available, please call him. Mr. M. Sharma. We'll call up again at 2 p.m. Just see. M. Sharma, UCO Bank.
This matter was heard in part, my lord, on the last occasion.
Was it?
Matter pertains to dismissal. The only two grounds is, my lord, they have opted for a suo motu review of the penalty and thereafter granted, my lord, the penalty of dismissal, which was beyond the period of limitation. And the second ground, my lord, is on parity. Similarly situated people who were also issued charge memos for the same incident, their penalty was not reviewed, and in fact, none of them were issued a penalty as harsh as the petitioner. Today, I had informed the other side also, my lord, Mr. T. Anik Singh, along with him, my lord, learned senior counsel, Mr. Sahewala, my lord, appears in the matter.
Where are they?
I called them, my lord, I called Mr. Anik Singh and informed him, my lord. In fact, the last order, my lord, has succinctly noted the facts, my lord.
According to you, the review could not have been taken more than beyond 6 months.
Right.
So the penalty was imposed on 12
Yes, my lord.
and the review show cause was issued on,
Review show was issued on
20.
23/2015.
so will it be 6 months?
It's 6 months and 10 days, my lord. Exactly. So the contention of the respondents, my lord, what
Yes.
what they like to project, my lord, they had issued an order of suspension, which my lord would find at page 114, which is dated 9/03/2015, page 114, my lord. My lord, may I read, my lord? Page 114.
9,
Page 114, annexure N,
114.
114. My lord, whereas Shri R.K. Nyog, so and so was charge sheeted in 2 cases under Rule 36 of the Conduct Discipline Appeal Rule, so and so dated so and so. Whereas inquiry was conducted and the CDA, that is the Director HR, in exercise of powers delegated under 35 of the ONGC Conduct Discipline and Appeal Rules, so and so had imposed the penalty of reduction of so and so, so and so, so and so on Shri R.K. Nyog. Whereas CMD, as the reviewing authority in exercise of powers vested under him under Rule 54 IBID, has decided to review the penalty imposed on Shri Nyog and place him under suspension with immediate effect. It is further ordered that during the period of suspension, so and so, so and so, and now this is the order of suspension. Now, with regard to this order of suspension was admittedly passed, my lords, issued after 5 months, 25 days. So if this suspension is considered to be the initiation of the review, in that case, my lords, it is within limitation. Now, what the petitioner submits, my lord, first of all, my lord knows, my lord is aware, my lord, suspension has to be in terms of the rules. So, the rule has to prescribe that in contemplation of review, a person, an incumbent, can be suspended. Now, the service rules are before your lordship, my lord. My lord comes to Rule 33.
Yeah.
The appointing authority or any other authority to which it is subordinate, or the disciplinary authority or any other authority empowered by the company by general, a special order to impose a penalty specified in Rule 34 may place an employee under suspension. It has been the yardsticks are A, B, and C, where a disciplinary proceeding against him is contemplated or pending. B, where in the opinion of the authority aforesaid, he had engaged himself in activities prejudicial to the interest or the scrutiny or the security of the state, where a case against him in respect of any criminal offences under investigation, inquiry, or trial. 2, where an employee is detained in custody, whether on a criminal charge or otherwise, for a period exceeding 48 hours, he shall be deemed to have been suspended with effect so and so. The employee shall also be deemed to have been placed under suspension from the date of his conviction, if in the event of a conviction for an offence, is sentenced to a term of imprisonment, so and so, so and so, so and so. My lord, it would appear from the rule, my lord, Rule 33, that 33 does not envisage a situation wherein in contemplation of a review, a person can be suspended from service. So that is the reason why, my lord, I have also challenged the order of suspension. It was not challenged earlier when we filed this writ petition. We have challenged the order of suspension, saying that the order of suspension itself is null and void. It's without jurisdiction. Because my lord would come to the power of review, which is at Rule 54. May I take your lordship to 54 for a moment? 54, you know? Yes. My lord has it. 54.
Where is the order of suspension again?
My lord, 114. Page number 114. 114 is the suspension. Thereafter, my lord, the next page, my lord, would find the show cause notice, wherein it was decided that they would review the penalty, and I was show cause. Page 115. The show cause is admittedly issued after 6 months, 10 days. So my lord comes to 54 for a moment, my lord. Rule 54.
54. Yes.
My lord has it, my lord. The authority to which an appeal against an order imposing any of the penalties specified in Rule 34 lies may, on its own motion or otherwise, call for the records of the case in disciplinary proceedings, review any order passed in such a case, and pass such orders as it may deem fit, as if the employee had preferred an appeal against such order. Now, my lord, what I understand from this clause, my lord, review can be made, there can be review of a penalty under two circumstances. It can be on its own motion, meaning thereby the department or the appellate authority wants to review the order of penalty, or otherwise. Otherwise signifies, my lord, in my respective submission, my lord, that if the incumbent, if the delinquent employee, he wants to review the penalty, he can also approach. My lords, thereafter, my lords, after, if it is decided that review would be done suo moto, first they would call for the record. My lord, it may also happen, my lord, when the authority, the reviewing authority, calls for the records, my lord, till that time the records are not available with the authority. It is available only when records are called. And after the authority peruses the record, my lord, two circumstances can arise, my lord. First, the authority can say, yes, this order has to be reviewed and issue a show cause notice, or otherwise it can also send back the records. And no, a review is not made out, it's not required to be reviewed. So till the time the show cause notice is not issued, it would not be considered as initiation. So, my lord, Janaki Raman has also settled this position, my lord. However, in a different my lord, context, what has Janaki Raman has held, my lord, the same question arose, my lord. When does a disciplinary proceeding initiate? Is it initiated the moment the person is suspended, or is it initiated at the time when the show cause notice is issued, my lord? So Janaki Raman has clearly distinguished and held that a disciplinary proceeding would only initiate when the show cause notice is received by the delinquent employee. Because, my lord, because this dispute arose because there were a lot of cases, my lord, in the country where a person, a delinquent employee, was suspended, and due to his suspension, he was not considered for promotion because it was said that since he's suspended, disciplinary proceedings have already been initiated. So that was distinguished by Janaki Raman, and it was clearly held that no, suspension merely cannot initiate the disciplinary proceeding. It is only when the show cause notice is issued. Now, similarly, my lords, in our case, the show cause notice was issued beyond limitation, my lord. That's an admitted fact. Now, what they have to, the other side, the respondent want to convey is that the suspension itself or the decision, my lord, my lord may find it in the file. I don't have the record. So that was taken prior to 6 months. Therefore, this limitation won't come into consideration. Now, my lords, there are judgments, my lord. In fact, if my lord permits, my lord, there is a judgment of the Andhra Pradesh High Court, my lord, division bench of the Andhra Pradesh High Court. Clearly on that point, my lord, it has also held, my lord, what I have submitted. If my lord may kindly pay you. And same has been followed by several high courts. My lords may directly come to page 877, my lord. The pages are marked at the top, my right side.
Para 6.
Para 4, my lord. 877.
Yes.
My lord has it. The question therefore arises for consideration in this context is what is the date with effect from which the period of limitation has to be reckoned for the purpose of making a review. In other words, whether limitation commences to run from the date on which records relating to the inquiry in the case were called for, or only from the date on which a show cause notice was issued to the delinquent officer. So, my lord, the question of law is exactly the same, my lord. Whether the decision to initiate would be termed as initiation, my lord would come to, my lord, thereafter, my lord, paragraph 5, the rule which the Honorable Andhra Pradesh High Court was discussing is pari materia with our rules, my lord. I'll read it out. My lord, 6. Any other authority specified in the special order may at any time, either on his own motion or otherwise, call for the records of the inquiry and review any order made under these rules, under the rules repealed by 34, from which an appeal is allowed, but from which no appeal has been preferred, and from which no appeal is allowed after consultation, so and so, so and so, so and so. And my lord, 5, Roman 5, I should have read it earlier. I'm sorry, my lord. The appellate authority within 6 months of the date of the order proposed to be reviewed. So the period is 6 months also. It's almost pari materia, my lord. Now, what was held by the Honorable Division Bench, my lord? My lord, may kindly come to paragraph 6, my lord. May I return paragraph? It was next contended by the learned counsel for the respondent that even assuming that no review could be made after the expiration of 6 months from the date of the order passed by the disciplinary authority, it could still not be said in the instant case that the proceedings initiated by the respondents are barred by limitation, as he called for the records within the period of 6 months. Now, in the instant case, they had also suspended me within the period of 6 months. That is also admitted. Call for the records within the period of 6 months. Though the notice calling upon the appellant to show cause why penalty should not be enhanced was issued only after the expiry of 6 months period, we are unable to accept this contention. Either, as already pointed out, the authorities mentioned in clause 5 and 6 of sub-rule 1 of rule 29 may at any time, either on its own, either on his or its own motion or otherwise, call for the records of any inquiry and review any order made under these rules. The words call for the records of any inquiry and review any order made under the rules would clearly show that the object of calling for the records is only to examine afresh the whole case wherever it is considered or felt necessary. If after calling for the records, the authority concerned should come to the conclusion that there is no need to review the order and drops the matter, it can certainly not be said that the step alone of his would constitute commencement or initiation of proceedings for review, as there would be no question of reviewing the order of the disciplinary authority in such cases. So the mere act of calling for records without anything more can certainly not be equated with initiation of proceedings for review. It is only when the authority competent to review decides upon proceeding further and issues a notice to the delinquent officer calling upon him to show cause why punishment meted out to him should not be enhanced, that proceedings for review can reasonably said to have been commenced. No doubt the authority can take a reasonable time for completion of the process of the review. It is not necessary to conclude the inquiry within six months, but it is imperative that the proceedings of review by the appellate authority should be commenced before the expiry of 6 months and from the date of the order sought to be reviewed. We are therefore in entire agreement with the learned counsel that the respondent was not entitled to call upon the appellant by his notice there is so and so to show cause as to why penalty imposed upon him by the disciplinary authority should not be enhanced, as the time limited for initiating proceedings for review had expired long before then. So, my lord, this squarely covers my case, my lord. In this case also, the show cause was issued after the period of 6 months. And the Honorable Court had held, rightly so, my lord, that it is only when the show cause notice is issued, it will be held to have commenced or initiated a review. In the instant case, admittedly, it is beyond the period of limitation. There is no dispute, even the other side is not disputing that. So, my lord, insofar as this ground is concerned, my lord, the impugn order of penalty pursuant to the review and the entire initiation of the review itself should be set aside as it is devoid of jurisdiction, being ultra vires the rules, my lord. And insofar as suspension is concerned, my lord, with regard to that, my lord, I have two submissions, my lord, like I have, my lord, submitted, my lord. First of all, my lord, Rule 54 does not contemplate suspension in contemplation of a review, my lord. 54 doesn't speak about it. Now, if 54 doesn't speak about it, we have to go to the clause which allows suspension, my lord, which is 33. 33 has categorically laid down the terms and conditions under which a person can be placed under suspension. And with all due respect, my lord, I do not fall within those circumstances, my lord. Therefore, the order of suspension itself is devoid of jurisdiction and void ad initio. Even assuming, my lord, suspension initiates, even assuming for a moment, not admitting, in that case also, it is devoid of jurisdiction. They could not have issued the order of suspension. And in any case, my lord, Janaki Raman and other judgments are clear along with this division bench judgment. Although, like I said, my lord, Janaki Raman deals with a different context, but still, my lord, it is that rationale can be drawn in this case also. It has been clearly laid down that a disciplinary proceeding would initiate only when a show cause notice is served upon the delinquent employee. So, my lord, insofar as initiation of review is concerned, on that ground, my lord, the prayer of the petitioner may be allowed, my lord.
Review will be initiated when?
Yes.
When?
It will be initiated the moment the show cause notice is given to the delinquent, wherein it is stated that we are.
Presupposes that the authority has taken it.
My lord.
The show cause was
Yes.
prior to happening.
So, my lord, till the time.
Why not? Why the process? You. What is the decision? Right.
Yes. Yes. So, my lord, in that point, so when the records are called for a moment, if the reviewing authority wants to review the penalty, he would call for the record. Now, he'll go through the
This is your alternative argument. First argument is that you not call for
review. No, my lord, the review, my argument is, my lord, because the initial penalty I did not challenge, I accepted the penalty, my lord. Thereafter, after 6 months, what I'm on, my lord, that the review could not have been initiated after the period of limitation. Therefore, the impugn order, which is pursuant to the review, is bad in law, my lord. That is my argument. The first, my basic argument, because the review itself is devoid of jurisdiction.
Where are your counterparts?
Yeah. Look, I'll ask my colleague to Mr. Anika call me. And there's an alternate argument also, my lord. Second argument, my lord. The second argument is on parity. Even for a moment, assuming, my lord, that review was permissible. Even assuming, my lord. So what had happened, my lord, in this, the charge against the delinquent employee, the petitioner, was that he had committed some forgery with regard to some tenders while he was working as a superintendent engineer with the ONG. Now, my lord, there was a tender committee. There was a tender committee who had initiated the tender, and all the people, my lord, who were involved, his superiors, one junior, everyone, some 3 to 4 persons, they were also issued similar charge memos, my lord, on the same set of allegations for the same incident, my lord. None of the other the persons against whom disciplinary action was issued, no one was issued such a harsh penalty of dismissal, which was issued in case of the petitioner. In fact, none of the penalties issued to the other delinquents were ever reviewed. It was only the penalty of the petitioner, which was suo moto reviewed, and he was dismissed from service. Now, what is the reply to that, man?
The
earlier punishment was reduction in 2-stage lower. That was also major penalty, major penalty, but I was given, I accepted. Now, my lord, what is the submission of the respondent? My lord takes up the affidavit in opposition. Yes. My lord.
Review is done, my lord, by the authority.
His primary grievance, the
Yes.
review is time barred
Time barred, yes.
beyond 6 months.
Yes. That I shall reply.
Now, it says that the show cause notice was issued. No, suspension was issued prior to expiry.
That is the main crux, my lord, because that is the limitation point. Because reviewing authority has to exercise the power within 6 months. And that has issued the notice putting him under suspension, so that the final order can be passed. So that is within time.
But suspension, on what basis you have issued suspension?
My lord, because
Rules are very categorical.
so that is to be reviewed. So
But suspension also is under the rules.
yes,
Rules have indicated the situations under which suspension is to be issued.
Right.
Review is not one of them.
I'm sorry. Because already punishment has been imposed, my lord. Already punishment has been imposed.
It has been
So,
imposed, yeah.
so my lord, that is open now.
What?
The reviewing authority has opened it. So when that reviewing authority has opened it, so he is to put under suspension, my lord.
No, you see rule 33.
Yes.
The suspension under what circumstances is to be imposed is provided for.
Yes.
So suspension rule 33(1). It has 3 situations. A, B, and C.
Yes.
So A is no longer there.
No,
Disciplinary.
that is, my lord, disciplinary proceeding, because that is not confirmed, my lord, finalized. Disciplinary proceeding is not finalized because although disciplinary authority has imposed a punishment, that is under review.
No, but once you impose the punishment,
Yes.
are you saying that punishment is not final unless it is confirmed by some authority?
My lord, if review power is exercised, then that is not final. Until unless review power is exercised.
So
If you also see, my lord, 35. Rule
review
35.
power will have to be exercised
My lord,
only
I am telling.
in terms of rule 54.
Yes. My lord. Well, suspension is not the crux of the matter, my lord, here, because it is only for a temporary period.
It is a review which is the crux of the
Review is the crux of the matter.
But review, if you look into the order of review
Yes.
for the show cause notice,
Yes.
is beyond 6 months.
No, my lord, it is your losses may just see, my lord. My lord, at page 114.
112.
114, annexure N.
11. Yes.
So it is within 6 months, my lord. If your losses see, that is, my lord, within 6 months. The final order is 12/9.
No, 114 is the suspension order.
Suspension will be, review power has been exercised, my lord, on that day. On that day, he said that I am exercising review power. It is not that, my lord, final order to be passed in that period. Reviewing authority has to exercise his power, and he exercises power, my lord.
Its review is on own motion.
Almost, because the offense is, my lord, too severe. My lord, if you also see the offense report, my lord, that will indicate, my lord, what he has done.
No, but you have already conducted a proceeding.
Yes.
You imposed the penalty,
Penalty.
major
Yes.
penalty.
My lord.
Then,
Thereafter review power is there, my lord, to the appellate authority.
yes, certainly.
Yes. So appellate authority can do that, my lord, because that is Supreme Court also said, my lord, this can be done. No, just I am relying on 92 for SCC page 10, my lord. Not publishing NIT, my lord, he has awarded the job, my lord. Totally, my lord, in violation of the. Appellate authority exercise the power of review in exceptional circumstances, my lord. Here the punishment is too minor, my lord, because he has committed a serious mistake, misconduct, my lord. It's a fraud, actually, it's a fraud, my lord.
There was no appeal.
They have not filed any appeal, because appeal can be filed only by the person, my lord, against whom the punishment is provided. So appellate authority can so moto, my lord, exercise the power of review. In case, my lord, punishment is given by the disciplinary authority is too low, my lord, minimum.
So where is the decision of the authority initiating the review?
My lord, that is, my lord, initiating the review, my lord, that I have placed, my lord.
No, I mean, under what circumstances the review has been initiated?
My lord, that final order, your lordship may see, my lord.
Page number?
The final order is at page Q, and extra Q, my lord. Page will be 126. May I read, my lord? This will suffice, my lord. Whereas an inquiry was conducted and the competent authority director, in exercise of power delegated by under Rule 35 to ONC Conduct and Disciplinary Appeal Rules 1994, had imposed the penalty of reduction to 2 stages lower in the time scale of pay for 2 years, with a further direction that he will not earn any increment during the period of such reduction. On the expiry of the said 2 years, increment shall be payable on the reduced basic pay only on Sri R.K. Neog, Bhai, order number so and so. Whereas the undersigned reviewing authority exercise power vested under him under Rule 54 reviewed all the records of the case in the dismissal proceeding against R.K. Neog, and on perusal of these records, the undersigned was opinion that charges against the Neog, which have been proved are very serious nature. My lord, this is the important matter. And therefore, the penalty imposed by the Disciplinary Authority was not commensurate to the gravity of the gross misconduct and deserved to be enhanced. Whereas keeping in view the gravity of the misconduct and proposed enhancement of in penalty, RKNA was placed under suspension by order number so and so dated so and so. Whereas RKNA was informed that the decision to enhance the penalty imposed by the Disciplinary Authority and opportunity was provided to him to make his defense, if any, against the proposed action, the memorandum even number so and so. Whereas RKNA has submitted a defense dated 22/4/15 in response to the memorandum even number so and so. Whereas the undersigned has produced the reply dated 22/4/15 of CRK Neog, and he observed that he has not been able to bring out any substantive material on facts and issues which merit dropping of the proposed review of penalty imposed upon him by the Disciplinary Authority by order dated so and so. It is found that Sri Neog committed forgery amounting to gross misconduct. Hello, this is which has been established beyond doubt during the inquiry, and therefore he is liable to for imposition of a penalty harsher than one imposed by the Disciplinary Authority. He lacks integrity, and his continuation in the service is undesirable and prejudicial to interest of ONC. Now, therefore, the undersigned, the reviewing authority in excessive powers conferred under Rule 54 of the ONC CDA Rules 1994, hereby set aside the penalty imposed by Sri Neog by the Disciplinary Authority under order 12/9/14, and instead penalty of dismissal from service, which shall ordinarily be a disqualification for future employment under government or a corporation, company owned by imposed with immediate effect on Sri R.K. Neog. It is further ordered that the period of suspension of Sri Neog shall be treated not on duty. Well, this is, my lord, if your lordship see what misconduct he has committed. Tenders have been settled without issuing an NIT, my lord. It's fraud, my lord, in fact. Normally, my lord, reviewing authority does not exercise power where authority. But this is a case, my lord, here punishment is not commensurate to the offense committed. Let me just see the inquiry report of party portion at page 104.
Yeah. Yes.
Yes. Page 104, my lord, last paragraph, my lord, page 15. Other, my lord, charges are proved. Lastly, he said, in the light of the facts and circumstances discussed above, it is proved that Sri R.K. Neog, SS so and so, while dealing with the tender number so and so as engineering charge during the 2009, failed to ensure publication and NIT of the said tender in 2 newspapers and keep their cuttings in the concerned tender file and kept 2 photocopies of a forged NIT purporting to have been published in Assamese News. Well, we are also see how we have done it. Paper, Ajir Doinik Batori, dated so and so, whereas the same was not published in the said newspaper or any other newspaper, and thereby he violated the requirement of clause so and so, so and so. RK thus failed to maintain absolute integrity and devotion to duty and behave in a manner unbecoming of the employee of the company, and further committed fraud in connection of business of the company, which were prejudicial to the interest of the company, and thereby contravention of the rules misconduct defined in so and so. So, my lord, this is the misconduct committed, my lord. How he can be kept in the service? So that is why, my lord, the reviewing authority has to enter into, my lord. Otherwise, normally, reviewing authority does not, my lord. The punishment provided is not commensurate to the, my lord, misconduct committed by him. The fraud, forgery, everything he has done, my lord. How this person can be kept in service, my lord?
No, first of all, well, it is not my submission that the department does not have the power of review. Like my lord has pointed out, Rule 54 empowers the appellate authority to review an order of penalty. That is settled, my lord. What I am on is that the mode, the manner how, my lord, the review was, my lord, initiated, that is bad in law, my lord. And how does the charges, whether it is forgery or any other thing, how does it matter, my lord? I'm not even on that. I had accepted something. I had committed a misconduct and I was penalized for that. I am only on the ground, my lord, that the review could not have been initiated after the period of limitation of 6 months, my lord. That is the ground. I'm not on whether what offense or what misconduct.
You look into.
And my lord, one more aspect, my lord.
You look into the tenor of
my lord.
114.
Yes. I'll satisfy your lordship on that.
Third paragraph says that the authority has taken a decision.
Exactly. Now, my lord, assuming a situation, my lord, I have placed a judgment, the Andhra Pradesh judgment, wherein the same submission was made on behalf of the respondents, that when they call for the record, my lord may kindly, my lord, appreciate, my lord, when they call for the records, that review is initiated. That was disregarded by the division bench of the High Court. There's a reason why, my lord. Now, assuming a situation, my lord, I have been penalized for a misconduct. Now, thereafter, within a period of 6 months, the appellate authority calls for the record. Assuming, my lord, within a period of 6 months, they call for the record. And they don't issue a show cause notice till 2 years, my lord. Or till 10 years. My lord would see the mischief, my lord. That is the reason why.
Here at serial number 3.
Yes, my lord.
They have decided to review. So
yes.
on 9th of March,
yes,
the decision was effectively taken to review.
My lord is aware.
Within a period of 6 months.
Exactly. I admit that, my lord.
Now you are relying on the division bench judgment to submit that this decision.
Yes.
Whether this decision was taken on 9th March after perusal of report.
Administrative authority takes a decision and keeps that decision on the file. Will it amount to, will it be effective? Now, what I'm on, only on this point, they may call for the record and they may decide within the period of 6 months that they may decide on the file that, okay, we'll review the penalty, but they don't issue a show cause notice till 10 years thereafter. Now, if they issue a show cause thereafter, can they say, my lord, that no, we had decided that on this point
the rules are very clear.
Yes,
you have to take a decision.
You have to, my lord, I'll read the rules again, my lord.
Take a decision.
Yes. Does not say take
calls for the record.
My lord, if a decision is taken and it is not communicated, likewise in a disciplinary proceeding, it would only initiate when I'm being
by 9th March.
Yes.
That they have decided to review.
But I have to, that is my submission with all due respect, my lord. They may decide within the period of limitation. They may decide, for example, they decide within 5 months, but they issue a show cause notice after 5 years of the first penalty, and they can still take that. They can still take that ground. My lord, will kindly appreciate.
We come to 114.
Yes.
9th of March. Is it within 6 months of your
9th of March is within 6 months.
Within 6
months. Yes, I agree to that.
9th of March order was served on you. When did you receive it?
No. It is not within 6 months. My lord, the show cause notice was 6 months, 10 days, my lord. Page 115.
No, 9th of March.
On 9th of March is, my lord, 5 months, 25 days.
Within 6 months.
Yes.
So within 6 months, they have taken a decision.
Yes.
And they have decided to place you under suspension.
Exactly.
Now, when was this order served?
Now, my lord, first of all, with all due respect, my lord, the order of my learned senior friend is referring to, first they have to satisfy this court that this is an order which is passed under some rule, my lord. What I'm saying, well, the order itself is without jurisdiction. How can you suspend a person in contemplation of a disciplinary?
It's a different aspect.
Yes, I understand.
But the decision to review under 54 is also reflected at para 3.
Yes, it is reflected, but until and unless it is communicated by way of a show cause notice, That is exactly what has been held by.
Showcause notice is to give you
Yes.
an opportunity.
My lord, I'll explain. My lord, in matters of disciplinary proceedings, for example, my lord, with all due respect, my lord, I am placed under suspension. My lord, it is not under all circumstances that a show cause notice will be issued. They may place me under suspension, and it may later so happen that the suspension is set aside without there being any initiation of disciplinary proceeding. Like I said, Madam Janaki Raman and other judgments are very clear. You take the decision whenever you want, but my lord,
And I don't bring in Janakira.
my lord.
Janakira,
Yes, yes,
you are trying to make the argument because this order has
yes,
one is suspension, the other is.
yes.
So, your submission that it- provision for suspension by contemplation or
Hmm.
may or may not be carried.
Hmm.
But there are three.
Yes.
One is the decision of
Yes, yes,
temporary,
yes,
and on the day the decision was made,
my lord.
well,
Yes, that I agree. So what I'm
so can you not say that this taking a decision is the initiation of the
my lord, with all due respect, it would only initiate only when I'm show cause that I know this order, whether suspension or they take a decision.
what
They don't ask the delinquent,
basis
my lord.
what basis are you
Yes.
it you
Yes.
can only be contemplated.
Yes, because I have placed judgments and I'm the ration the logic what I'm on. They may take a decision, my lord, at within the period of limitation, but until then, unless they issue the show cause notice. Yes.
Initiation of
Yes. When does it initiate, my lord? The Andhra Pradesh High Court division bench judgment is very clear on that. In that case, also, what had happened, they had called for the records and decided that they'd be reviewed. But the show cause notice was issued prior to the limitation period of 6 months. And the court had, that is the reason the court had held that no, it is only when the show cause is communicated, only when they're, because my lord, merely putting me under suspension till the time I'm not show cause, that would not amount to the initiation, my lord.
we are not on that.
Yes.
We are only on this interpretation of Rule 54.
54, well, I'll read 54 one,
is very
one
clear.
second. 54, I'll read it once.
Proceeding shall, sorry,
Yes,
no action under this rule shall be initiated.
yes,
More than 6 months.
Hmm.
So will initiation
exactly.
not include the decision
No,
taken by
no,
the
no.
authority?
In my humble submission, my lord, initiation would be at the time when the show cause notice is issued, my lord.
What-
Because there are judgments I have produced, I'll produce other judgments also. And my lord, because my lord, if they take a decision and keep it in the file, for example, or if they, my lord, without a show cause notice, so they can issue the show cause, elongate it, my lord. And there is no certainty with regard to the penalty imposed. And my lord, the other aspect I've not pointed out, that is also, I'll point it out, my lord. My lord, like I've submitted, my lord, for the same allegation, my lord, there are other,
That's on a different.
yes, yes,
We are on the,
yes, yes. The other is also, my lord, very substantial, my lord. That is why, if I may,
that you're alleging malafide.
no, not malafide. I'm saying parity in penalties.
Parity penalty.
Yes.
Okay, then going to examine the record, find out what your involvement.
No, no,
One or
that,
the other.
no, that would appear from the affidavit itself. Well, I'll just directly read the affidavit in opposition. I mean, I'll also satisfy on the other point also, but I'm just, because I didn't make this point earlier, my lord. The affidavit in opposition, if my lord takes up the affidavit in opposition of the respondent. Hold on. My lord, the affidavit in opposition. Paragraph 18. This paragraph 18 is in reply to my contention that there was no parity in penalty. I was issued a more harsher penalty, whereas all the other incumbents were equally involved in the case. Paragraph 18. They reply to it. I'll read it. that the submission made in paragraph 23 of the writ petition being incorrect, misconceived, the same are denied by the answering deponent. The statement everment made in the writ petitioner to the effect that the incumbents alleged of the same misconduct, namely Sri G.C. Saikia, Sri V.C. Tai, Dr. Yen, having been issued similar charge memo, were treated more leniently than the writ petitioner, or none of the above mentioned officials were treated as harshly as that of the petitioner being not correct. The same is denied by the answering deponent. And the answering deponent begs to state that the decision taken by the reviewing authority in case of other officers is based on facts and circumstances pertaining to the cases against them. The petitioner was guilty of forgery and he was also in a habit of committing forgery. Well, this in a habit of committing forgery, it was neither included as a charge in the charge memo, or it was not a finding of the inquiry officer that I was habitual in committing forgery. This has been later, committing forgery in respect of other tenders, which has been established during inquiry. This gross misconduct made him rendered his continuation in service undesirable and prejudicial to the interests of the company, and also made him liable for more harsher penalty than others. It is denied that the action of the respondent authority is in clear violation of Article 14 of the Constitution of India. Now, my lord, one more aspect, my lord. Lordship, there is an interlocutory application, IA number 2179, my lord. For the same misconduct, my lord, a criminal proceeding was also initiated. My lord, the judgment is here, page IA 2179. I'll refer to. Yes, yes. My lord, exonerated, and my lord, I'll just read one paragraph of the judgment. The present case has arisen out of the FIR dated so and so by one Narendra Prasad Pandey, ONGC so and so, whereby it is alleged that the accused persons, namely Ranjan Neo, who is the petitioner, Sri Ganesh Chandra Soikia, Sri Girish Chandra Tai, and Sri Doyara Mian, are found to be involved in committing forgery by usage of fabricated and bogus documents with regard to tender number such and such. So all these persons were alleged of the same misconduct, that we committed forgery for these tenders, my lord. There were some subordinate officers, some superior officers, my lord. Thereafter, when everyone was penalized, no one was dismissed from service, even the petitioner in the first instance. But it was only in the case of the petitioner that it was later reviewed after 6 months, and I was imposed the highest penalty of dismissal, my lord. My lord, in this regard, my lord, I'll just place two judgments just to satisfy your lordship, my lord. The first,
were there any appeal filed by the other person?
no, my lord, because they also accepted only my matter was reviewed, and similarly situated persons were given, my lord, issued lenient penalty. My lord, just give me a minute, my lord. I'm so sorry, my lord. No. My lord.
Yes.
Yes. Now, para 9, I won't trouble your lordship with the other judgments. Para 9, doctrine of equality applies to all who are equally placed, even among persons who are found guilty. The persons who have been found guilty can also claim equality of treatment if they can establish discrimination while imposing punishment when all of them are involved in the same incident. Parity among co-delinquents has also to be maintained when the punishment is imposed. Punishment should not be disproportionate while comparing the involvement of co-delinquents who are parties to the same transaction or incident. The disciplinary authority cannot impose punishment which is disproportionate or lesser punishment for serious offences and stringent punishment for lesser offences. It is said, my lord, parity would also come into play, my lord, in cases where persons are found guilty. Now, for the same offence, if a co-delinquent is issued a lesser penalty, my lord, it would be arbitrary, my lord. Next, my lord, like to place another judgment, my lord. Now, Bongaigaon Refinery, my lord, is aware, my lord.
It's here, it's here.
Yes. Now, in the case of Bongaigaon Refinery, my lord, there's a committee, likewise, like here, my lord, in the present petition, there's a tender committee who had decided, and there were some anomalies in the tender, and only one person was penalized. Now, what the Honorable Supreme Court says, my lord, I'll just point out two paragraphs. Yes. The paragraph 18, my lord. I'll just read few lines, my lord, from the bottom 4 lines, my lord. If the decision of the committee stinks, it cannot be said that the respondent alone stinks. It will be arbitrary. If all fish stink, to pick one and say only it stinks is unfair in matter of unanimous decision of the committee. Thereafter, my lord, next paragraph 21, again from the bottom, my lord, 4 lines. If the respondent is targeted and all the members of the committee are equally responsible, therefore such findings given by inquiry authority cannot be countenanced. Similarly, so far as the appointment of Shri I. Sharma is concerned, the respondent alone was not responsible. The Bongaigaon Refinery clearly held, my lord, there has to be parity among court delinquents. Only one person cannot be made scapegoat, my lord. In the instant case, I have shown from the judgment of the session court, my lord, where I was acquitted, there are similar allegations against all the other delinquents, my lord. And none of them have been issued the order of dismissal. And that has been admitted in a way in their affidavit in opposition. Because in the affidavit in opposition, they say that yes, because I am in the habit of committing forgery, which is alien to the inquiry report, my lord. That statement is not there, that I'm in the habit of committing forgery. If the respondents points it out, it is, I couldn't find it, my lord. So their decision was based on something which is not based on the inquiry.
Okay.
And my lord, insofar as the first ground is concerned, my lord, I would again, my lord, just for a moment, my lord, this the Andhra Pradesh High Court judgment, my lord. I'll just my lord, just give me a minute, my lord. My lord, the division bench judgment, my lord. My lord, would kindly consider the division bench was considering a rule which is perimeter to Rule 54. And I'll again read paragraph 6, my lord, from the middle, my lord. May at any time, either in his own motion or otherwise, call for the records of the inquiry and review any order made under this rule. The words call for the records of any inquiry and review any order made under these rules would clearly show that the object of calling for record is only to examine afresh the whole case whenever it is considered or felt necessary. If after calling for records, the authority concerned should come to a conclusion that there is no need to review the order and drops the matter, it can certainly not be said that that step alone of his would constitute commencement or initiation of proceedings for review, as there would be no question of reviewing the order of the disciplinary authority in such cases. So the mere act of calling for record without anything more can certainly not be equated with initiation of a proceeding for review. It is only when the authority competent to review decides upon proceeding further and issues a notice to the delinquent officer, calling upon him to show cause as to why the punishment meted out to him should not be enhanced, that proceedings for review can reasonably be said to have been commenced. Now, in similar circumstances, the division bench of the Honorable Andhra Pradesh High Court has held, it doesn't matter when you call for the record, or even if you take a decision behind the back. The initiation in terms of Rule 54 would only initiate the moment the show cause notice is served. And there's a logic behind it, my lord. They can take a decision anytime and they can issue a show cause notice maybe 10 years later. Will the delinquent?
On night.
Yes, yes. But that is this.
The argument that you make is that either contain the file or a ticket by way of a show. May not by but not serve the suspector and that order itself. That proceeding.
Insofar as the first.
Now the only question is whether to take record.
Yes. 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 Yes.
And your question.
So, my lord,
Parity.
yes. My lord saying, my lord, that order whereby I was suspended because they have.
No, unless you say you the proceeding. No decision.
Yes.
Unless communicated by.
Yes, yes, that is, I'm on that, my lord.
What?
This Andhra Pradesh is one, my lord.
Andhra Pradesh
Squarely covers the people, but I'll if my lord. Okay, my lord. So I would have to satisfy this court, my lord, that only it is only when the show cause is served.
That is your
Yes, yes, yes. So my lord would give me a day, my lord. This Andhra Pradesh judgment is there. I'll come up with few Supreme Court judgments, my lord.
He has relied on another judgment. And he is also hard on the question of merit. Because the other person involved may issue same with the further proceeding by disparity.
That depends on because he is the main officer, my lord. He is the main officer who has issued the tender, my lord, said it, is to issue the tender, my lord. Other may be assisting him, my lord, that is another aspect of matter. That is a different aspect, my lord. They may be assisting him, my lord. But he is the main person, my lord, who has.
The findings are same, my lord, with respect to all the officers, my lord, that they have committed forgery with regard to the same tender. One is superior, one is junior, one is reviewing authority.
Who is the?
In that case, lordship may also request my learned senior friend to get the record. That would be necessary.
Keep the record and
my lord, records it will take time, my lord.
If required, posting it on 21st.
My lord, one order may be passed to that effect, my lord, regarding record, my lord, so that we can. Only day,
any day except 21st, any day, my lord, as per my lord's convenience.
But last week I shall not be here, my lord. 1 week. On 24th, 31st, I shall be out of. It may be in the June, my lord, in that case, 4th of June.
Make it on
22nd.
Yes. 22nd.
Okay. We have
yes.
Time now.
Necessarily, my lord. It will go, everything will be better. My lord.
I'll get hold of judgments, man.
The respondent direct
deeply obliged.
Yes.
My lord,
Yes.
your lordship, can you see order at 18-4, my lord?
Yes, PTC.
Include is a different thing, my lord. Your lordship, kindly 16-27, my lord. 17, we are fighting for our
No,
salary.
who are you?
And I have filed an impleadment application. When Mr. K. Chaudhary will appear in this.
Who are you?
Lord, we have applied for the post pursuant to advertisement, which is in page number 135, and there are two advertisement, my lord. So we have
Now,
applied for this,
they are essentially asking for their salary.
my lord.
So how, why do you have to, why are you seeking impleadment?
Lord, if I can take you through this, I would first pray that Mr. K. Chaudhary may appear in this.
All right. But
He earlier, he came for that, he appeared for that. He
That-
appeared.
He was here, my lord, he was in like
So, my lord, your lordship, kindly take up that, my lord, that's what happened to my lord, that is
No,
order
the
passed by this honorable.
impleadment is one aspect.
my lord.
The, what about the salary part? Why this matter has been going on and on and on?
18-4-24.
Why the salary, what was
Let me get
done?
the instruction, my lord.
Initially, the fact was that there was
Yes, sir.
election.
Their
and-
salary part, my lord, all these petitioners were appointed and left all these petitioners in a non-sanctioned post. The writ petitions, bunch of writ petitions were filed. All petitions were rejected, dismissed. Then went for the appeal. An appeal, a policy decision was taken, wherein these persons, later on, 1009 persons were taken back, my lord. After sanction by the state, by the finance department. Now a position has come, my lord. Altogether, among the petitioners, my lord, there are few persons to be regularized. That is around near about 314 persons, my lord. So the process is on to regularize all these persons, because subsequently 1,216 persons, 16 posts for sanction has been granted by the state government. The process is on. Moment the model code of conduct comes to an end, we will announce that they are,
What is model code of conduct?
because the model conduct is there, so their processes have been stalled, my lord.
Why? Under what provision?
If lordship directs, we can do it. Only thing
Yes,
is
of
model
course,
conduct.
there are several orders earlier.
Already there.
On what basis are
Already
you saying
there,
that court
already
orders
there.
are
Because
something?
they have decided, no, different model code, we'll start giving appointment to all these persons.
Sorry?
No.
Because in the midst of the model code of conduct there, we'll have to appoint.
We are doing it under orders of the court. At least you take a decision.
Lordship will take it, then there is no
That
difficulty,
decision
man.
has not yet been taken.
But then there is no difficulty. Lordship gives a direction, man, even if the model code of
Already
conduct.
several directions are
We are
there.
ready to announce that, man. Process, already that verification has been already been done, man.
In fact, this
Only
they
because
are
in between
giving
the
effect to,
election has come, my lord.
in fact, lordship, they are giving effect to an order of 2015. All that they.
Sorry?
This BTC is just to give effect to an order of regularization of 2015. There are no fresh orders to be passed. So this model code of conduct is neither here, neither there, lordships. The order is
The
of
orders are coming.
2015. They are for
Because all
some
these
reason or the other
109
not paying
persons have
salary.
already been regularized. Most of them are getting their salary. Only few
Yeah,
persons
that is
are
the whole
delayed.
problem. These 421 wretched souls are still struggling to get their salaries, lordships. So we request, even on the last occasion, lordships, we had requested that please pass an order that they be at least be given salaries. They are working since 2015 without a rupee. It's a human issue, lordships, for them.
So what exactly is your problem for release of salary?
Release of salary, these are not persons who are not in a non-sanctioned post. Cannot be released in salary because the BTC has no the financial authority. Financial authority comes from the government of Assam. Even we have, I will hand over a document, my lord. Even to release the salary in 2017.
Repeatedly, they are, my lord, giving a same thing, my lord. Your lord, the high time to, my lord, take a contempt issue against the Shomoto.
There are contest pending, my lord. They can implement the present incumbent, my lord. They have not done it.
In fact,
They
if
know
I may
that
just,
there are
if
supplementary
I may
demands are
just
made to the
for a
government of
moment
Assam that
take,
has not
lordship
been
will kindly see
has not
order
been
dated 18/12/2023.
passed, my lord.
Please kindly see order dated 18/12/2023. If Lordship may kindly see order dated 18/12/2023, passed by your Lordships. 2023. Please see what this court has recorded on their submission. Eighteen 2003 order,
Yes.
Lordships. May I read the second paragraph?
Yes,
It is
yes.
their submission, Lordships, to the
Yes,
court.
please.
Mr. B. Gogoi, Learned Standing Counsel Finance, has placed the communication dated 14/11/2023 and submitted that the proposal contained file number so and so is under active consideration of the department of the proposal for filling up of 1216 number of assistant teachers under BTC area. It is further submitted that the 421 teachers who have claimed to have not received any salaries are also included within this 1-to-1 loss of assistant teachers under the PTC area. He therefore submits that the department decides to approve the proposal, then the prayer for release of salary of including these 421 teachers will be covered. As such, he prays for further time to complete the instructions.
Yeah, where is Mr. Gogoi?
This proposal has been sanctioned. 21 teachers doesn't lie in their mouth, Lordships.
421 teachers are left to be get the sanction, but in the meantime, 1216% sanction has been granted. These 420 people will get the process is on, my lord. That's why the instruction today has been process is on. That will come because of them and see the process has been stalled. If Lordship direct, we can proceed and give the appointment. There are some other persons. All the petitioner out of the more than 1,000, they have
Then
already
Lordship
been,
will give a
already been
subsequent
appointed,
order.
my lord, and getting salary.
Lordship will then see the subsequent order, 1st of February 2024, again by your Lordships, where Lordships record the fact that sanction has been now granted. And therefore, on the last occasion, Lordship directed that then please tell us what you are doing to release salaries. And this is continuing for so long, Lordships.
No, what is the status now of this
Status?
413?
413, Lordship will, that exact process of giving appointment to all these 430 the process is on. And Lordship in the first paragraph itself, that particular line, 314 numbers of doctors have already been scrutinized. They are made a list, my lord. And they are subsequently, after the, they have contemplating that after the
They are included in this 1216 posts.
yes, they 1216 out of the 1216 posts that sanction. This person will come in. Out of this writ petition, most of the writ petition will be taken care of.
Now, what is the status of this 1216?
1216 people who have got sanction for appointment. The left out will be advertised, already had been advertisement when done. And these among these 1200.
You tell us this 421, is it a part of 1216 or it is over and above?
No, 1216. 12 is a part of 1216. Among the we have get sanction for 1216% we have got it, and out of which this person will be the petitioners in the bunch of petition, they will be appointed. So that scrutiny is going on.
What is going on? What is the
That scrutiny of whether they are working or not, all these things scrutiny that list has been prepared, my lord. And immediately after I see this other person have got appointments, salary of all the that numbers of petitions have got salary appointment. At the same process they will get it.
No, you give us in facts and figures. What is the process that you have undertaken till imposition of penal code?
Yes, ma'am. That process is almost in the coming to an end, my lord. That because then, my lord, I have to.
How many teachers' cases have you verified? What is the result of this verification?
That can be done, my lord.
You are required.
In the very first paragraph, it is in that list of 4 numbers of dot which are already been prepared, my lord. 314. Already been prepared, my lord. This is almost ready, my lord. Thereafter, only the process of appointment is left, my lord. Among those sanctioned posts, 1216. And for the 1216 posts where advertisement been granted, that's why that IA has been filed to stall the entire process. They want to stall the entire process of appointment of these petitioners as well as those
advertisement, my lord.
Who wants to talk?
That
My lord, we have filed one IA where we are seeking impleadment in this proceeding. Lordship, to kindly permit me that IA is 684 of 2020.
Just 1 minute.
Yes.
Just one. Just go to this instruction. Yes, I don't know.
Item number 2. Come on. One, item 1.
Yes, anyway, we may carry. Yes.
Actually, my lord, what had happened, these applicants, my lord, they are all TAT qualified of the batch of 2020-23. Now, we are all aspiring to become assistant teacher in LP and ME schools. Now, my lord, situated thus, there was an SIU approval for 1216 posts. Pursuant to that SIU approval, 2 advertisements were issued. Now, my lord, these posts, which are supposed to be filled up by advertisement, are sought to be accommodated by these people. That is our grievance. So we say we're a necessary party to this proceeding. Therefore, we should be heard in opposition to the claim of the petitioners, where they say that they have a right to be accommodated, or as far as payment of salary is concerned, that neither we are supporting nor we are objecting. We have got nothing to say on that. Our only case is, my lord, out of these 1216 posts, which was, given SIU approval, in respect of those posts, there should be an advertisement and it should be filled up by open advertisement. It cannot be, my lord.
But these 1216 posts,
Yes.
out of that
900 and odd has already been appointed. Now the balance, it should be, my lord, should not be filled up by any other method, my lord. Merely because at some point of time, somebody has, actually I appeared for some of the teachers, my lord. They were, I think for a period of 2 years, they were appointed. They were terminated way back in 1999. There they had a grievance regarding non-receipt of salary. Now, my lord, we also filed a contempt. Now BTC has filed an affidavit in that case where they have come up with this stand, except 8 teachers who have paid the salary to all. So that chapter is over. And regarding payment of salary to somebody who worked earlier, that is neither we are opposing those prayer, my lord. Our case is the remaining posts which are there, it cannot be, my lord, filled up by somebody who entered service through my back door, my lord. That cannot be. And this is precisely against the scheme of Article 14 and 16.
you should file a separate petition.
No, my lord. We can, no, my lord. We can always oppose them.
Oppose them.
Yes, yes.
You're
Yes.
the policy of the government.
No, government has not taken any policy decision. At least government has not filed any affidavit to that extent. That's why, my lord, we are before your lordships. If government takes a policy decision, certainly we'll challenge. Government has, I don't think, to the best of my information.
Initially, there was intention was 1009. That has been accepted. Thereafter, recently, the month of December 2023.
No, SIU approval was of 17/1/24. SIU approval, I think.
In the month of December, that is 1,216 additional has come, out of which 314 people or 400 something people have to be accommodated the petition. Remaining already have been advertised, have been done.
Where are these facts and figures?
Yes.
Why are you not bringing it on?
I'll have to bring it down.
Let them file an affidavit.
My lord, your lordship. My lord, I'm just, in my case, they are filing a implicit petition. I am submitting, my lord, before your lordship. This case is going on till 2017. Very interestingly, till today, no affidavit has been filed by the authority, my lord. Now, your lordship kindly see, our service has been regularized by the order. Your lordship kindly see one order, my lord. Now, my lord, they are Every time they are taking a different view, my lord. Your lordship kindly see, my lord, item number 1, my lord, your lordship kindly take up.
Writ petition.
Read petition, my lord.
Yes.
আমি কিমান দিনে ফাইল কৰিছো?
Yes.
One data point, I'm looking at my class of intent, I got him.
Huh?
Data point,
I am very clear regarding payment of salary.
No, these all petitions are payment of salary, nothing more than
No,
that.
more salary I put for nine.
Then why you are impleaded? Your lordship kindly says page 58, my lord. Page 58, my lord. Page 58.
Petition can go.
Yes.
In pursuance with the Honorable Guwahati High Court judgment order dated so and so, by date appeal dated so and so, the consequence of BTC Executive Council, the department meeting Education Department dated so and so, respectively, in accordance with the approval received the BTC by order dated so and so, so and so, so and so. The Ganesh Nadari, who was terminated from the service by the order dated to the student is hereby withdrawn, and his service is regularized and retained as the assistant teacher of the so and so LP school scale of pay so and pass other so and so. So a regularization of the service of the individual teacher shall be subject to the following terms and conditions. The regulation of the order shall came into effect from prospective effect. The supplementary demand for proposal for individual teacher has to be made by the Director of Education for an annual submission of the WP so and so. The drawal of the regular salary of the individual teacher till 2006 has to be authenticated by the DDO and so and so. This is the order by this our service has been regularized. But 2015, that order was passed in 2015. Till today, we are not getting his salary. So that's why our case is, my lord, that since we are working, our salary has to be given, and this order is still exists, my lord. That is not been set aside by any court or nothing, my lord. They have not been challenged, my lord. And there are several orders, your lordship kindly see, passed by this honorable court and reflecting all this order, my lord. Now, well, only question of that salary. Now they came with it that some of them are again, once we are already regularized, how they can second time regularize, my lord? Now say that some of the petitioner has again regularized, my lord. But we are concerned with the salary. Your lordship kindly see the pair of my petition, my lord. Only salary, my lord. Since my learned friend is no objection to the salary, my lord, then why, my lord, he is implemented in my case?
Because the government has taken a stand.
My lord.
You, that your salary can be payable only upon regularization, isn't it?
Only
My
regular.
lord will kindly come to
Only
page
regular.
35. Well, let us see what is the prayer in the writ petition. Please come to page 35.
Yes.
In the premises aforesaid, it is therefore prayed that your lordships may be pleased to admit this petition. Call for the issue rule calling respondents to why, show cause as to why, written the nature of statutory shall not be issued. Setting aside the prospective effect of reinstatement and regularization of the petitioner's service as assistant teacher, and or why written the nature of mandamus shall not be issued, directing, commanding respondents to give effect to the order of regularization of service of the petitioner with retrospective effect, that is from the date when their initial appointment, with a further direction to BTC authority to regularize petitioner's termination as period on duty and to realize arrear as well as current salaries. So their first prayer is, my lord, that their regularization should be made retrospective. Only when the regularization is made retrospective, then only, my lord, the question of paying their salary would arise. Arrear salary. But now my submission is, you do whatever you like, but not at the cost of these posts which are advertised, which are subject matter of an advertisement. Once an advertisement is there, my lord, I have a right of consideration. I may get the job, I may not get the job. And moreover, these people are not qualified. They do not have TAT. Yes.
Not being filled up.
Yes.
According to you, or are likely to be used for absorbing this.
No, lordship, definitely I have taken note of that, what has fallen from your lordships. But it will be too much to say on my learned friend's part that I am not a necessary party to this proceeding. There is an advertisement. In terms of that advertisement, some posts are there where we can apply, where I have a right of participation in the, I have a right of consideration against those advertised posts. Now, somebody is claiming that he should be regularized against those posts, and government is also endorsing the same, and will be, my lord, remediless.
You have applied.
Yes.
You have applied. Pursuant to the
advertisement.
There is no
now we apprehend, my lord, as this appears from the government's submission before this honorable court.
Perhaps subject to correction. the proper approach would be to,
That, as I've already submitted, my lord, I have taken note of that.
had it been a case that you are already appointed or appointment orders have been issued, notwithstanding that these posts are now being sought to be converted for temporarily, correct, for the necessary part.
Yes.
As on date, no appointment orders have been issued.
No, but that's why I want to implicate myself in this proceeding to oppose that prayer of the petitioners.
But on what basis?
So that is their prayer. They should be regularized retrospectively, meaning thereby against which post? My lord, to regularize, there must be a post.
Why did the state comes up with a government, an affidavit,
Not
stating that these are the posts which we.
They have said.
No, my lord,
That's
no
why, my
affidavit
lord.
file, my lord, no affidavit
No,
file.
the order to
No
go.
affidavit file.
My lord, kindly have this order. Please have this order, my lord. Please come to that first para, my lord, sub-para. Mr. B. Gogoi, learned standing counsel, finance has placed the communication dated 14/12/23 and submitted that the proposal contained in e-file number so-and-so is under active consideration of the department as the matter requires proper evaluation for sanctioning of the proposal for filling up 1216 number of assistant teachers under BTC area. It is further submitted that 421 teachers who claim to have received salaries are also included within that 1216 number of assistant teachers under the BTC area. He therefore submits that if the department decides to approve the proposal, then the prayer for release of salary, including the 421, will be covered. As such, he prays for further time to complete his instruction.
Now, how many posts were advertised?
Total 1216.
That is wrong, lordships. I
Come on,
point
please.
out, that's the whole fallacy of the argument.
Advertisement to the Gathi Disuno.
Yes,
My
yes,
lord.
I will be very good.
No, my
That
lord,
is the
I'm
whole
sorry,
fallacy
my
of the
lord.
argument,
That
lordships.
number I may not be correct, but they say
Yeah.
the posts are covered by that SIU approval.
No, 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 no.
Yes. Advertisement is IA, my lord, page 135.
Yes.
January 24.
Yes.
Please come to that first subpara. The number of vacancies has been approved by Finance SIU department and communicated by Department of School Education. Write approval letter. This is the number, my lord. E259464/1465 dated 29/12/23. The candidate who submits online application will be able to select the district, medium, etc., etc.
So
Now
the-
this is one for, my lord, upper primary, and page number 142 is for the lower primary.
May I?
We will come to you, Mr. Koso.
The number of
Yes, yes,
vacancies
please.
has been approved by Finance SIU department and communicated by the Department of School Education while approval letter number so and so. So 29/12.
So this is the same proposal, e-proposal.
So that includes 1216 posts. That's why we are saying 1216.
Yes, Mr. Goswami.
Well,
In
before
that
my learned
same
friend Goswami
advertisement, which
starts, my only prayer today is,
So
my
we
lord,
want to hear.
let state file an affidavit,
Right.
making their position clear. Then your lordship will take a call in the.
Yes, Mr. Goswami.
And we have taken note of what has fallen from the lordships, my lord. If necessary, we might come up with independent petitions also.
Yes. You wanted to say something?
in that same advertisement, that 17, bottom of the page, that is at page 136, clause 17. Very important. As lordships have seen that no posts have been identified, that how many posts are being advertised. It says the
How many-
vacancies may vary due to administrative reasons and matter under sub judice before the Honorable High Court.
No, that is
So-
for the government to
So
decide.
the
That's for the
respondents were
government to
very conscious of the fact that these 1216 posts are definitely not for TET pass. applicants alone.
But the proposal number is the one and the same.
And
The e-file number is one and the same.
yes, Lordship, but the whole thing has to be read. Lordship is absolutely correct. But today, Lordship,
Yes, yes,
What
Mr. Bora,
needs to be
I think you need
advised
to clarify.
is whatever it has now come, this 1216, is a continuation of a process which was reflected in the division bench judgment of 6/2/2015. So, which is a division of a 6/2/2000. So, through an
No,
IA,
we
can
are,
a
we are only, we are
bench
only
order be
concerned now,
challenged?
Mr. Goswami, this is with regard to the IA which has been filed, whether they are necessary and proper
And
parties.
ultimately,
Now, the submission of Mr. Chaudhary is that
they are not at all
it
neither
is on
necessary,
this,
neither
it is the
proper.
same file, same e-file proposal which has been sent and which is reflected in the order which was passed earlier. So there appears to be some confusion as to whether
True.
this particular proposal is meant for filling up the posts relating to the writ petitioners, or is it meant for the advertisement?
1216 post has been sanctioned.
To be
According to petitioner, there are 400 on the post persons are there to be filled up.
1216 posts are sanctioned for filling up in what manner?
As I have it is given the sanction, because there was a policy decision.
Sanction for what?
Teachers will be there.
For filling up? How? By what process?
Ultimately, there should be an advertisement, but there are petitioners that from the down to 116 posts, those persons will already find their petition, they will be, that process, they will be accommodated. That process is on. That's why in the very first, that communication manner that.
So this e-proposal.
Remaining there will be advertisements, remaining posts will be advertised, already advertisement granted, we will participate and that post will be utilized, sanction post will be utilized. Because there are persons who have to be accommodated. The idea of 109 post is sanction.
How many applicants are there in the advertisement? In the IA?
241.
241.
Enough more than 241.
My lord, my submission before your lordship, kindly see, my lord, this is our petition is 2017 till today, they have not filed affidavit, my lord. Let them first file affidavit, my lord, till today. That's why, my lord, they are, my lord, they're taking different view in different date, my lord. Why they are not filing affidavit?
Correct. Time to execute with them. They were all appointed illegally.
My lord, illegally they cannot say, my lord, now. This is happened by writ appeal, in person to writ appeal order.
Subsequently, large numbers of more than 50% have been allowed and accommodated.
No, if you are illegally, then remove us, my lord. We are not dead, because as per the court order, we have many regulations, my lord. That regulation, 2015, we are regulation. So now, my lord, very surprised, my lord. Let them, my lord, file an affidavit on that effect, my lord. Why they
I
last
totally
7
agree
years?
to what my lord and senior friend is saying. This is a culmination of a division bench order. How can we be now?
7 years, my lord.
And lordships, and lordship will also be aware that today the people who have filed an application for impleadment, they do not have a right today.
We'll consider that application on the affidavit being filed by the respondents. You file it. You file it within a period of 2 weeks. I think sufficient opportunity has already been granted. Why 3 weeks? You just need to put in the position, that's all. You bring it, you bring the facts and figures, you put it on record.
Let them file affidavit in our case, my
In the
lord.
meantime, would lordships
Why not
consider granting us the
Yes, in
salary?
the writ petition.
It is very, very harsh on us, lordships.
Item number 1.
Already,
Yes, heard counsel for the party, Mr. P.J. Monto, assisted by so Mr. M. Goswami, learned counsel, and the Mr. R. Sinha, MSK Devi, and please give the names, whoever are there in the respective petitions. Mr. S. Bora, learned counsel appearing for the PTC. He is permitted 2 weeks' time to file an affidavit to bring on record the total number of vacancies available and sanction for the process of filling up of the posts by the writ petitioners. And if as to whether any further posts are available for being filled up by way of direct recruitment pursuant to advertisements being issued by the government. Stop. The affidavit must also contain the the present status of the process stated to have been undertaken by the competent authority in the department or towards filling up of the vacancies, regularization of the petitioners, and for the release of their area salaries as claimed. Mr. Radhor for Welfare of Boroland Department, Mr. P.N. Sharma for Department of School Education, Mr. Arbor Pujari for Finance. The other respondents are also at liberty to file their necessary affidavit. Stop. In the IA, you write, or you make it a part of common order. Para in IA so and so, Mr. K.N. Chaudhary, Learned Senior Counsel, assisted by Mr. A.W. Rahman, submits that this IA has been filed for impleadment of the applicants as necessary parties in the present petition, namely WPC 6020, as the applicants had filed their necessary applications pursuant to the advertisement issued on 17th of January 2024 for filling up of vacancies in assistant teacher, science teacher, Hindi teacher in upper primary schools. Is there a separate one for lower primary also? Yes. And similar advertisement being issued for filling up of assistant teacher, science teacher, and Hindi teacher in lower primary schools. Stop. The grievance of the writ petitioners, the grievance of the applicants are that the vacancies have been approved by the Finance SIU department and communicated to the Department of School Education by the approval letter number E 259464/14665/1465 dated 29/12/2023. Stop. The applicants had all applied through online applications and claimed to be duly qualified and TET passed. And therefore awaiting proper selection and appointment to these posts which are advertised. The Learned Senior Counsel submits that if that pursuant to the advertisement, when the posts are advertised for filling up by way of direct recruitment, then these posts cannot be / ought not to be filled up by way of regularization by the government as have been sought to be done by accommodating the writ petitioners. Stop. As directed, as permitted, the respondents will place the current position in respect of the vacancies available sought to be filled up by way of the advertisement dated so and so, as well as the vacancies available for regularization of the writ petitioners by way of the affidavit as directed within a period of 2 weeks. Any affidavit that is filed, copies thereof may be circulated amongst the respective writ petitioners. Matter be listed again on 31st. 31st May.
Can it be on a week thereafter, Lordships, 6th or 7th?
You agree on a date, we'll pass the order. Is 6th of May, 6th of June, all right, Mr. 6th of June?
Convenience.
How to acquiesce, that's what they, I'm gonna decide for myself.
6th of June?
My lord.
Okay. This matters again on 6th of June. 6th of June.
6th of June is fine, Lordships. Would Lordships, would Lordships also make one observation
No,
about our
let the affidavit
salaries?
come.
Well, ultimately, Lordships, everyone is
Let the
getting except
affidavit
this
come.
421.
Facts,
My
facts
item
will
is
be clear.
My item number is 33, my lord. In this matter, my lord, lordship, the matter, my lord.
Very well. Grateful,
Sorry?
Lordships.
The segregated matter
Why?
will be segregated
Why?
because issues are mine, repetition issues are different, my lord. I was already provincialized employee, my lord. My and thereafter reinstate was done, my lord, and
Let
retired.
it, we will consider that segregation on the next date.
Right.
Let it be there.
All right.
Yes, any development?
Yes, your lordship, only yesterday we have collected the duly signed form from the petitioner. And we are under process and it will take 3 weeks more time to, I think, to settle down the issues.
But there is a decision taken to settle down.
Yes, your lordship, there is
So then we
nothing.
can close the petition.
Your lordship.
We can close the writ petition.
Yes, your lordship, but I think
Provided-
senior, I think.
If your lord may kindly direct the bank officials to disburse the retirement benefits at which I am entitled to at the earliest.
What decision has been taken?
Your lordship, that we have, that Mr. Salindranath Kakoti, the petitioner, could not able to travel down to the bank branch. So itself, the branch manager has taken all initiatives to went to his home to collect the forms, and we are under process to send it to the zonal office for necessary sanctions and payment, your lordship. Your lordship may fix the matter in the first week of June, so that I think in the meantime, payment may be made.
It is submitted by Mr. M. Sharma, done at Standing Council UCO Bank, that the decision has been taken at the zonal office to grant the pensionary benefits payable to the petitioner. And for that, the necessary papers and documents required from the petitioner has already been collected and the matter is under process. He submits that the matter be called up after 3 weeks, by which time the proper necessary orders for settlement of the pension may be issued by the bank authorities. So the submissions made by the learned standing council is not objected to by the learned council of the petition. The matter be called up after 3 weeks again.
Much obliged.
Matter be listed again on
First week of June, your lordship.
4th of June.
Much obliged, my lord.